that my learned brothers will now their own order to save time. Because the petitions are consolidated. So now we will go to the main petition in petition number 3. In bringing this petition, the petitioners who were contestants in the presidential elections held on 26 February 2023 have challenged the declaration return of second respondent as the winner of the election and sought for the declaration and consequential reliefs, which I have reproduced in the beginning of this judgment. The petitioners have predicated their petition on the 3 statutory grounds earlier stated. Although in the ruling of this court on the objections of the respondents, some paragraphs of petition replies have been struck out for stated reasons, this court will take into consideration the entire affirmance in the petition and determine the merit otherwise of the petition in interest of justice. At trial, the petitioners opened their case to tendering from the bar several certified true copies of electoral and other documents which were objected to by all the respondents, who reserved the reasons for their objections to the state of final address. Said objections were therefore admitted, the said documents were therefore admitted and marked as exhibits without prejudice to the objections of the respondents. The court ordered the respondents file separate addresses on their objections along with their final addresses. Proof of their petition: the petitioners called 13 witnesses who gave evidence as PW1 to PW13. Of those witnesses, only 3 had their witness statements on oath filed along with the petition, while the other 10 were subpoena witnesses whose statements were filed separately after hearing in the petition had commenced. The respondents objected to the competence of the subpoena witnesses, give evidence and adopt their addresses, witness statements on oath, and reserve the rulings for their objection to the state of final address. Without prejudice to the objection, state witnesses adopted their respective witnesses' statement on oath, after which they were duly cross-examined by all the senior counsel for the respondents. Upon closure of the petitioner's case, the first respondent, as well as the second and third respondents, called one witness each in their defense. The fourth respondent did not call any witness, but opted to rely on the evidence already adduced by the other respondents and that elicited under cross-examination on behalf of the fourth respondent. At the close of evidence, parties filed and extended their respective final addresses, including separate addresses, in support of their various objections which they raised during trial. So we shall now consider the respondents' objections to the competence of some of the petitioner's witnesses and to the documents tendered by them during trial. To save time, we skip the addresses of counsel, go to the resolution of those issues. So, the resolution of the respondent's objections to witnesses and documents contained in page 84 of the judgment. On the first segment of the respondent's objection, all the respondents challenged the competence of PW3, PW4, PW5, PW6, 7, 8, 9, 10, 11, and 13. And the respondent's essential contention is that the witness statements on oath of those witnesses of the petitioners were not front-loaded along with the petition, but were only filed during trial, contrary to paragraph 4 of 5D of the pay schedule to the Electoral Act 2020. Section 285, 5 of the 1999 Constitution as amended, which limits the time for presidential election petition, provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the elections. In the same vein, Section 132, sub 7 of the Electoral Act 2022 provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the elections. Paragraph 4 of the first schedule to the Electoral Act 22 stipulates the contents of an election petition which shall be filed. In particular, paragraph 4.5 of the state schedule mandates as follows. The election petition shall be accompanied by A list of the witnesses that the petitioner intends to call in proof of the petition, B, written statements on oath of the witnesses, and C, copies or list of every document to be relied on at the hearing of the petition. Paragraph 6 of that paragraph, a petition which fails to comply with the above requirements shall not be accepted for filing by the Secretary. Paragraph 14, sub 2 of the same first schedule, the Electoral Act, then provides as follows. After the expiration of the time limited by A, Section 132, sub 7 of this Act for presentation of the election petition, no amendment shall be made. 1. Introducing any of the requirements of paragraph 4.1 contained in the original election petition file, or 2. Effecting substantial alteration of the ground for or the prayer in the election petition, or 3. Except anything which may be done under subparagraph 2A, Roman 2, affecting a substantial alteration of or addition to statements of facts relied on to support the ground for or sustain the prayer the election petition. And sub B, paragraph 12, for filing the reply, no amendment shall be made. 1. Alleging that the claim of the seat or office by the petitioner is correct or false. 2. Except anything which may be done under the provisions of paragraph 2A, Roman 2, affecting any substantial alteration to, in or addition to the admissions or the denials contained in the original reply filed or to the facts set out in the reply. The above quoted provisions of the Constitution, Electoral Act 2022, and the first schedule thereto have been thoroughly considered by the Supreme Court in several cases, including Okian and other versus Mimiko and others, Ogumbi JC, Oba and Vincent Rarume and others, Anik, Okuru, Ogi and others, PDP and Okuru and several others listed here. In Oke and Mimiko, the upper apex court, Ogumbi JC, held as follows in the court. Paragraph 4, 1 and 5 of the first schedule to the Electoral Act, the composite analysis of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive, mandatory, conclusive. In other words, the provisions do not allow for additions, and hence, the procedure adopted by the appellants in seeking for an extension of time is nothing other than a surreptitious attempt to amend the petition. This is obvious from the nature and substance of the application, especially where one of the grounds seeks to put in facts which are allegedly not available allegedly not available at the time of filing the petition, but only came into their possession after the statutory time limit allowed for the presidential election petition. Expressly, there is no provision in the legislation which provides for extension of time. What is more, in paragraph 14.2 of the first schedule to the Electoral Act, the appellants by section 134 sub 1 of the Electoral Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting the application. The saying is true that even the devil does not know a man's intention. It can only be inferred from the act exhibiting that which is conceived in the heart, mind. The use of the word shall in paragraph 14 sub 2A of the first schedule to the Electoral Act mandatory and places a complete bar on any form of amendment to a petition file and does not allow for an exercise of discretion whatsoever. Further still, on a critical result of the application, Relief 2 seeks to call additional witness to which with AEO. It is pertinent to state that at the close of pleadings, parties have submitted the list of witnesses who were to testify together with their depositions. The idea, purpose, and intention of the application is suggestive of nothing more but a clear confirmation seeking for an order of an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions section 285(5) of the Constitution, section 134 of the Electoral Act, clause of court. In his concurrent judgment in the same case, Nguta, JSC, specifically stated as follows: the court, the additional or further witness depositions sought to be allowed for a just and fair determination of the petition are fresh facts as found by the tribunal, and which finding was endorsed by the lower court. This court will not interfere with a concurrent finding of fact of the two lower courts when the appellants have failed to show a special circumstance for this court to do so. Election petitions are time-bound, and the court will not allow the party to resort to any sort of subterfuge or to frustrate the intention of the Electoral Act that petitions be disposed of judiciously. The petitioners in this case have relied on the earlier decisions of this court in Omidiran versus Ete, Lasun versus Awoyemi, Supra, to argue that the subpoena witnesses whose witness statements on oath were filed outside the time limited for the presentation of the petition are competent to testify because they are subpoena witnesses who do not work for the petitioner. However, it is pertinent to observe that unlike in the present case, the subpoena issued at the instance of petitioner in the case of Omidiran and Ete and Lasun versus Awoyemi were decided under the Electoral Act of 2006, which did not have provisions similar to paragraph 4 sub 5 of the first schedule to the External Electoral Act 2022. Secondly, the subpoenas in the above two cases were issued and served on adversaries, namely the resident electoral commissioners. Again, those two cases were decided before the introduction of Section 285 subsection 6 of the 19th Constitution of Federal Republic of Nigeria 1999, which mandates that an election petition shall be decided within 180 days from the date of filing of the petition. Thus, whilst this court in Omidiran and Ete and Lasun versus Awoyemi appeared to have adopted a flexible approach, the Apex Court had taken a strict approach in its latter decision in OK and Mimico. Indeed, in subsequent following the Apex Court's decision in OK and Mimico, this court, per Agim JCA, as he then was, now JSC, highlighted this strict position of the law in Ogba versus Vincent at paragraph 46 to 48, paragraph A to B, wherein he held as follows: our court. I think that this court in Omidiran and Ete and the Supreme Court in OK and Mimico adopted different approaches in addressing the issue of whether a tribunal or court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election petition proceeding. Omidiran's case did not strictly enforce the time limits prescribed in Section 141 of the Electoral Act 2006. The provision in the first schedule thereto on prohibiting the introduction of additional facts in the proceedings after the period allowed for filing the petition and closure of pleadings, and paragraph 1 sub 1 of the Election Tribunal and Court Practice Directions of 2006 on the content and form of the petition, held that the purpose of the practice direction is to guide and regulate compliance with and observance of the provisions of the first schedule to the Act and the Federal High Court rules where applicable. This elastic application of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the Electoral Tribunal and Court Practice Directions as overriding the rules of court in election court cases. In Oke and Mimico, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The Supreme Court has consistently, in a long line of cases, insisted on this strict and inelastic approach, opposing the electoral laws. The law has laid out systematic juries in Oke and Mimico is that a witness deposition that is not filed along with the petition within the 21 days allowed for filing the petition cannot be filed in the proceedings. It held thus, if there was an evidence which was fundamental to determination of the petition, that evidence ought to have been placed willy-nilly before the tribunal within the time limit specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition. Even if it has been withheld by any person, there are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this. The petitioners ought to have restored to that procedure, laws of court. The firm position of the Supreme Court, as stated in Oke and Mimico and followed by this court in Oba and Vincent Supra, is that by the combined provisions of Section 2855 of the 1999 Constitution, Section 137, Subsection 7 of the Electoral 2022, and paragraph 4, 5, and 6 and 14.2 of the first schedule to the Act, every written statement on oath of the witness which a party intends to call must be filed along with the petition within the time limited by Section 208.55 of the Constitution of the Federal Republic of Nigeria as amended, and Section 132, Subsection 7 of the Electoral Act 2022. Once the time limited for filing of a petition has elapsed, the contents of the petition cannot be added to or amended in any manner or under any guise. Any written statement on oath of a witness filed outside that 21 days limitation will amount to a surreptitious amendment of the petition and a breach of paragraph 14 of the first schedule to the Electoral Act 2022. This is irrespective of whether the witnesses to be called are ordinary or expert witnesses and whether they are willing or supine witnesses. Since then, this has been the consistent position of the law followed by this court. Indeed, in Okuru versus Obe, this court says this position, our learned brother Bolaji Yusuf stated that a quote, from the records, PW3 and PW4 was summoned by subpoena issued by the tribunal and presented as expert witnesses. The question is whether this without more entitled the appellant to file their statements on oath outside the time set for filing a petition. Or a reply to the respondent's reply in answer to the petition. I am of the humble view that whether an expert witness or not, a witness remains a witness. So the proviso to Order 3, Rule 3, Sub 1 of the Federal High Court Civil Procedure Rules 2009 made applicable to an election petition by paragraph 54 of the first schedule to the Electoral Act provides that the statements on oath of witnesses requiring subpoena from the court need not be filed at the commencement of the suit. 2. The witnesses who require subpoena or summons shall, at the instance of the party calling them, be served with civil form 1A before the filing of the statements by witness. The application of that rule is with regard to and or subject to the provisions of the Electoral Act, not independent of the Act. Paragraph 54 reads, subject to the express provisions of this Act, the practice and procedure of the tribunal or the court in relation to an election petition shall be as nearly as possible similar to the practice and procedure of the Federal High Court in the exercise of its civil jurisdiction, and the civil procedure rules shall apply with such modifications as may be necessary to render them applicable having regard to the provisions of this Act, as if the petitioner and the respondent were respectively the plaintiff and the defendant in an ordinary civil action. The provisions of the Electoral Act being a substantive law shall override any rule of court which is contrary to its provision. The subsidiary legislation must conform with the principal law, CNNPC and Afamfa Oil Limited, the proviso to Order 3, Rule 3.1 of the Federal High Court Rules 2009 cannot override or affect or whittle down the absolute and mandatory provisions of Section 285 of 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, which stipulates that an election petition shall be filed within 21 days after the date of the declaration of the result of the elections, and paragraphs 4, sub 1, 5, and 14.1 and 2 of the first schedule to the Electoral Act, which stipulate the content of a petition. It is therefore clear that in law, the provisions of Order 3, Rule 3.1 of the Federal High Court Civil Procedure Rule 2009 cannot provide a platform for filing and using witness statements on oath not filed within the time limit set for presentation of petition, and which time cannot be extended for any reason under any guise. The focus of our decision in Ogba and Vincent Supra was the injustice in allowing a piece of evidence not covered by the pleadings to be presented to the court when the opposing party would have no opportunity to react to it. It is my humble view that the position of the law, as can be gleaned from the Section 2855 of the Constitution, paragraph 4, 14.2, and 16.1 of the first schedule to the Electoral Act, is that a petitioner cannot be allowed to file and use documents or witness statements on oath filed outside the time set for filing petition, and to which the respondents would have no opportunity to react. To do so will amount to creating an avenue which a petitioner can use or exploit to overreach the respondents. That is the stand of the Supreme Court, Oke and Mimiko, number 1 Supra, followed by this court, Oba and Vincent Supra, those of court. Again, in Ararume and another, but Anik and others, in which I wrote the lead judgment, therein are stated as follows. The law, therefore, is that the deposition of a witness must accompany the petition at the time of filing the petition. In other words, the written statement on oath of an intended witness must be filed along with the petition. Thus, any written deposition of a witness not filed along with the petition will not be countenanced by the court or tribunal. Therefore, means that a written deposition filed by a witness not listed in the petition nor his deposition front-loaded cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. I think that is what the trial tribunal decided in this case, in line with the decision in Oba and Vincent. The combined effect of paragraph 4.5, Roman 1 and 2, 14.1 and 3 of the first schedule to the Electoral Act is that no witness can testify in chief before a tribunal if he has not deposed a written statement on oath, which must necessarily have been filed along with the petition. Close of court. From the foregoing judicial decisions, it is clear that in election petition litigation, whether the witnesses which a party intends to call are ordinary or expired witnesses, and whether they are willing or supine witnesses, their witness depositions must be filed along with petition before such witnesses will be competent to testify before the tribunal or court. It is instructive to observe that one of the leading senior counsel for the petitioners in this petition, Dr. Onyechi Ipiazu, SAN, was the lead counsel to the second respondent in Ararume and another versus Anik and others, wherein he successfully challenged the competence of a subpoena witness, Ama Ibom Agu, PW2, on the same ground that the witness statement on oath of the said witness was filed on 8/7/2019, long after the time limited for the filing of the petition. Therefore, the petitioners in this case were well aware of the settled legal position on subpoena witnesses in election petitions, favored by the Supreme Court and by this court. Yet they embarked on subpoenaing PW3, PW4, PW5, PW6, PW7, 8, 9, 10, 11, and 13. 10 out of their 13 witnesses whose witness statements on oath were not front-loaded along with the petition. The petitioners have tried to argue that the said witnesses are witnesses of this court. With respect, this argument is misconceived because the subpoena in respect of those witnesses were issued upon the request of the petitioners. The applications for the issuance of the subpoenas were duly signed filed at the registry of this court by the Petitioner Counsel and the requisite fees paid, including filing fees and service fees as assessed, were duly paid by them before this court approved and issued the subpoenas. Therefore, those witnesses are the petitioner witnesses and not witnesses of this court. Indeed, the procedure for calling of witnesses by the court is by summons as stipulated in paragraph 42, sub 1 of the first schedule to the Electoral Act 2022. By the provisions of that paragraph, the tribunal or court may summon a witness as a witness who appears to the tribunal or court to have been concerned in the election. Clear from the provisions of that paragraph that is a person summoned by the court suo motu in exercise of its powers under paragraph 42(1) that is a witness of the court and not a person subpoenaed at the request of a party to the case. In the instant case, PW3, who was subpoenaed at the request of the petitioners, is a staff of Channels Television who tendered exhibits PBH3 and PBH4, two flash drives containing third annex consultative meeting with leaders of political parties held on 26 October 2022, an interview with Mr. Festus Okoye, National Annual Commissioner, held on 12 March 2023, respectively. PW4, a professor of mathematics who was engaged before the election by the petitioners and whom the petitioners presented as a subpoenaed expert witness, stated under cross-examination by the first respondent that he concluded his report on the 19th of March 2023 before the petition was filed. PW5 is the staff of Arise Television who also tendered exhibit PCG2, a flash drive showing the INEC chairman delivering an address at the Chatham House, London, UK, on the preparations for the 2023 elections in Nigeria. PW6 is a staff of African Independent Television, AIT, who tendered exhibit PCH1, a flash drive of the program Democracy Day, anchored on 22nd November 2022, wherein the INEC chairman was shown giving a brief on the preparations for the 2023 general elections. PW7, who claimed to be a cloud engineer and architect working with Amazon Web Services Incorporated, tendered exhibits PCJ3A to F, which are 6 reports of Amazon Web Services AWS Health Dashboard, which she said she downloaded from the Amazon website. Under cross-examination, however, she not only admitted that she is a member of the second petitioner. Please, let us be serious. This is a serious matter, it's not a laughing matter. She not only admitted that she is a member of the second petitioner, the Labour Party, but she had contested elections as a candidate for the second petitioner for House of Representatives elections, conducted along with the president elections on 25th February 2023. PW8, who claimed to be a cybersecurity expert, engaged by the Labour Party on 10th March 2023, stated that he produced his preliminary report on 17th or 18th March 2023 before the petition was filed. He tendered exhibit PCK1, a metadata. PW9, a staff of Women and Child Rescue Initiative, a non-governmental organization, claimed to be an observer in the 25th February 2023 elections, but stated that the subpoena was addressed to him personally and served at his village address. PW10 claimed to be an annual ad hoc staff who acted as a supervisor. He stated under cross-examination that the subpoena was addressed to him personally and not through INEC. PW11, who is a staff in the Legal Services Department of National Information Technology Department Agency, NIDDA, stated that the subpoena was addressed to him personally instead of his organization. As for PW13, who claimed to have acted as a presiding officer in the 25th February 2023 elections, he stated that he was on a subpoena. The subpoena, which was admitted as exhibit PCR, was, however, addressed to him personally and not through INEC. It's pertinent to observe that the above 10 witnesses subpoenaed by the petitioners were all witnesses who were available to the petitioners at the time of filing the petition. They were neither subpoenaed as adversaries nor subpoenaed as official witnesses. It is therefore beyond controversy that the witness statements on oath of those witnesses filed after the time limited for presentation of the petition had lapsed are incompetent, and the same witnesses had no virus to testify in this petition. Their testimonies are embodied in their respective witness statements on oath, being incompetent are accordingly struck out. With regard to the respondents' objections to the admissibility of documents tendered by the petitioners, the first objection raised by the respondents is to exhibits tendered through PW4, as to exhibits tendered through PW4, 5, 6, 7, 8, and 8. These are exhibits PCD1, PCD2, PCD3, PCE1, PCE2, PCE3, PCE4, and PF2, tendered through PW4. Exhibits PCG1 and PCG2, tendered through PW5. Exhibit PCH1, tendered through PW6. Exhibits PCJ1, PCJ2, PCJ3, A to F, and PCJ4, tendered through PW7. And exhibits PCK1 and PCK2 tendered through PW8. The said exhibits I have estimated them in the judgment. The respondents' essential argument is that since the subpoenaed witnesses and their witness statements on oath are incompetent, the documents tendered through those witnesses cannot be countenanced by the court. By paragraph 41(3) of the first schedule to the Electoral Act 2022, oral examination of witnesses is not allowed. Witnesses are only to adopt their respective written depositions and tender in evidence all disputed documents or other exhibits referred to in their depositions. By paragraph 4(5)(b) of the schedule, such written depositions of the witnesses must be filed along with the petition. Since the above exhibits are documents, including expert reports, which were tendered through the subpoenaed witnesses whom we have already declared incompetent because their witness statements on oath were filed in violation of the mandatory provisions of paragraph 4(5)(b) of the first schedule of the Electoral Act 2022, the documents admitted through them, which form part of their evidence, are inadmissible and liable to be expunged from the record. In the case of Buhari and INEC, the petitioners have also argued that since the parties have agreed during pre-hearing session that documents properly certified by INEC will not be objected to, and the said documents were tendered from the bar pursuant to pre-hearing order of this court of 23rd May 2023, the parties are bound by the order of the court, since same has not been appealed against by the second and third respondents. However, this contention of the petitioners does not represent the position of the law. It is stated that a court is not permitted in any event to admit an act on it's stated that a court permitted to act in any event to admit an act on legally inadmissible evidence, even if such evidence had been admitted by agreement of the parties or under order of court in the course of hearing. Once such evidence is legally inadmissible, the court must reject it when giving its final judgment, even if that will amount to overruling itself by so doing. Ishanu and AfriBank are OY for JSC. Indeed, even in the case of Sani and Akwe, relied upon by the petitioners, this court at paragraph 20, paragraph B2A, restated the position of the law that even when pieces of evidence had been improperly received in evidence, trial court as well as appellate court have the power to expunge it from the record and decide the case only on legally admissible evidence. On the objection of the respondents to the admissibility of the documents tendered as expert reports by the petitioners, which were admitted as exhibits PCD1, PCD3, PCE1 to PCE4, PCJ2, PCJ3A to F, and PCK1, the respondent's contention is that they are caught up by the provisions of Section 83, subsection 3 of the Evidence Act 2011, having been contrived for the purpose of this petition. It is settled law that, as provided in Section 83, subsection 3 of the Evidence Act 2011, and pronounced upon in several decisions of the appellate court, that a document which is made by a party interested in a pending or anticipated proceeding involving a dispute as to any fact which the document tends to establish is inadmissible in evidence. Thus, in Latwaja and Ajimobi, where the Supreme Court, Peter Odili, JSC held as follows: our court, in respect of what is referred to as a person interested, I shall refer to the cases of Nigeria Social Insurance Trust versus Cliffco, Nigeria Limited. As regards the phrase, a person interested, I agree with the respondent that the phrase has been examined in the case of Ivan versus Noble, where a person not interested in the outcome of an action has been described as a person who has no temptation to depart from the truth, one side or the other. A person not swayed by personal interest, but completely detached, judicial, impartial, independent. In other words, it contemplates that the person must be detached, independent, and non-participant, and really not interested which way in the context the case goes. Normally, a person who is performing an act in official capacity cannot be a person interested under Section 91 of Section 3, which is now the Section 83.3. I think the phrase, a person interested, ever more so, has been quite definitely put in the case of Halton and Halton to mean a person who has pecuniary or other material interest in the result of the proceeding, a person whose interest is affected by the result of the proceedings, and therefore would have no temptation to pervert the truth to serve his personal, private ends. It does not mean an interest in the sense of intellectual observation or an interest purely due to sympathy. It means an interest in the legal sense, which imposes something to be gained or lost. CPC and Ombugadu, when considering and determine who is a person interested under Section 91.3 of the Evidence Act 2011 held thus. By the provision of Section 91.3 Evidence Act, a person interested is a person who has a pecuniary or other material interest and is affected by the result of the proceeding, and therefore will have have a temptation to pervert the truth, serve his personal, private ends. In fact, it is in its most recent decision in Oetola and another versus Annex, the Supreme Court, Agim JSC, restated this position in the following words: the other evidence adduced by the appellant to prove their case is the expert analysis report prepared by PW1, who by his own admission is a member of the second appellant and had been a special assistant to the first appellant and was engaged by the appellants to establish the invalidity of the disputed results in Form EC8A for the 744 polling units. It testified further that I made the report as directed by the petitioners and that I am part of those who wrote the petition. By his own testimony, he established that he was not an independent expert, as he had an interest in the subject of his analysis, carried out the analysis from the conclusion that the results were invalid. He testified to support the contemplated election petition. It was an analysis from an answer and not from a question. Such a report is not the product of an independent, impartial, detached, and professional analysis. He is clearly a person with the disposition or temptation to depart from the truth. The listing of the expert analysis report in the petition among the documents to be relied on to prove the petition show it was made in anticipation of contemplation to be filed. The report having been made by PW1 as a person interested in the subject matter of the petition when the petition was anticipated, was anticipated to establish that the election result was invalid is not admissible evidence by virtue of Section 83(3) of the Evidence Act 2011 as amended. Close of court. In the instant case, EW4, who claimed to be an expert, was contracted by the petitioners before the election to carry out data analysis on the results of the presidential elections held on 25th February 2023. He even tendered his letter of engagement by a second petitioner dated 20th February 2023, which was admitted as Exhibit PCF2. According to him, he produced his initial report on 19th March 2023. His report was made a day before this petition was filed on 20th March 2023. Obviously, the report Exhibit PCD1 to PCD3 was prepared in anticipation of this petition. As for PW7, who also claimed to be an expert witness, he admitted that she was not only a member of the second petitioner, but had contested the House of Representatives election under the platform of the second petitioner, which election was conducted the same day with the presidential election on the 25th of February 2023. He also admitted that the report she presented in Exhibits PCJ A to F are public information posted by Amazon, which she downloaded from the Amazon website, and that the open access information she downloaded in her report cannot be amended by her. This shows that PW7 was clearly not the maker of the said documents. As for PW8, who claimed to be a cybersecurity expert, he stated under cross-examination by the first respondent that he was engaged by the second petitioner as an expert on 10th March 2023, and that he produced a preliminary report on 17th and 18th of March 2023, and final report, Exhibit PCK1, at the end of May 2023, while this proceeding was pending. It is therefore evident from the above that PW4, PW7, and PW8 are persons interested in the outcome of this proceedings. The reports produced by PW4 and PW8 qualify as statements made by persons interested in anticipation or during the pendency of this petition. As for PW7, he is admittedly an interested party, having been a member of and even contested election under the umbrella of the second petitioner. Her interest is further underscored by the fact that she admitted under cross-examination that she was attending court throughout the proceedings prior to her evidence. By virtue of Section 83, Sub 3 of the Evidence Act 2011, the reports tendered by those witnesses which form part of their evidence are inadmissible. In view of the foregoing, exhibits PCD1 to PCD3, PCE1 to PCE4, PCF to PCG2, PCH1, PCJ1, PCJ2, PCJ3A to F, PCJ4, PCK1, and PCK4 tendered through the incompetent PW4, 5, 6, 7, 8 are hereby extended from the record of this court. The second aspect of the respondent's objection is on the ground of improper certification or authentication. On the second respondent's objection to exhibit PBP1 to PBP21, the IRF report for Adamawa State on the ground that no certificate of authentication of those computer-generated documents was filed in compliance with Section 84 of the Evidence Act 2011. Exhibit PCB1 to PCB6, referred to by the petitioners in response to the objection, are IRF certificates of compliance for Bayelsa, Benue, Ekiti, Niger, Ogun, and Rivers States. Adamawa State is not included in those exhibits. Exhibit PCC1 to PCC28, which include Adamawa State, are actually Beavers reports and their certificates of compliance. That of Adamawa is PCC21. In short, no certificate of compliance was produced by the first respondent in respect of exhibit PBP1, PBP21. The blood IRF reports exhibits PCA series in respect of Adamawa State. However, since the documents were stated to have been downloaded from ANEC's RF portal and were certified by ANEC as true copies of what they have in their RF portal, the documents qualify as public documents within the meaning of Section 102 of the Evidence Act 2011, and the certification by ANEC authenticates those documents. Therefore, the provision of Section 84 of the Evidence Act is not applicable in this case. This is the position of the law as espoused by the Supreme Court in the case of Kubo and Dixon, where the Apex Court held that the computers from internet-generated documents printed from the website of a public institution is a public document, and only a copy of such document which is duly certified in compliance with Section 104 of the Evidence Act 2011 admissible. That I've started the victim of Supreme Court by a cast ASC court. Exhibits PBP1 to PBP21 having been downloaded from ANEC report and duly certified by ANEC are clearly admissible. As for the fourth respondent's objection to Exhibit PCG2, the flash drive tendered by PW5, the staff of Arise TV, it is clear that the said witness had in paragraph 6 to 12 of his witness statement on oath not only stated that he participated in all stages of the recording, production, and packaging of the flash drive, but he had certified the process of his production as required by Section 84 of the Evidence Act. On the fourth respondent's objection to the admissibility of Exhibit X2, on the ground that the Exhibit X2 was obtained by the petitioners from the registrar of this court and not from the custodian of the original copy, we have examined Exhibit X2, which is the European Union Election Observation Mission Nigeria 2023 final report. As rightly observed by the fourth respondent, a photocopy of the document is certified by a secretary of the Presidential Election Petition Court and not any officer of the European Union Election Observation Mission, which is the custodian of the original copy of the document. By Section 104(1) of the Evidence Act 2011, the secondary evidence of any public document is only admissible in evidence if it has been certified by a public officer having custody of the original copy of the document, who by that section may give a copy of them to any person who has a right to inspect, together with a certificate written at the foot of such copy that it is a true copy of such document or part of it as the case may be. Under subsection 2 of that section, the public officer is enjoined to certify same by subscribing his name, official title, and date, and why he is authorized to use a seal with his seal. Clearly, the registrar of this court, who is not the custodian of the original copy of Exhibit X2, cannot validly certify that document under Section 104(1) of the Evidence Act 2011. The Omisori and Arebeshola, Manuel vs. Umana, where Mwezi JSC stated that the whole essence of the court's insistence on the scrupulous adherence to the certification requirements of public documents is to vouchsafe their authenticity vis-à-vis the original copies. Since Exhibit X2 has not been validly certified, it is inadmissible in evidence. Accordingly, Exhibit X2 is expunged from the record. The third aspect of the petitioner's objection to the petitioner's document is on the ground that the petitioners failed to plead specific facts to cover the documents objected to. The said documents objected to by the respondents are exhibits. There are so many, they have been listed in this judgment. Get the judgment, you will see them. I have carefully examined the petitioner's pleadings and the documents objected to by the respondents. The petitioners have specifically averred in paragraph 101 of the petition that they will be relying on all the first respondents' electoral and all other necessary documents used for the conduct of the presidential election, including the documents which they listed as items A to PCC of that paragraph. However, election petitions are sui generis, and it is settled that for an averment in an election petition to be competent, material facts relating to complaints made therein must be pleaded. Belgore and Ahmed Yazoo, and OT. In the latter case of PDP and ANIC, the Supreme Court was categorical on this mandatory requirement of specificity in affirmance of election petitions when the court held as follows. On whether the affected paragraphs were rightly struck out, I have read the affected paragraphs and found that they relate to allegations of non-voting, several polling points, corruption of election, non-conclusion of election, some printing of ballot papers, falsification of election results, widespread disruption, irregularities and malpractice without providing particulars or the polling units where the alleged malpractice took place. The lower court was therefore right when it held as follows. Paragraphs above, in my view, are too generic, vague, and lacking in any particulars, as they are not tied specifically to any particular polling unit or any particular number of people who were alleged to be disguised. The fact that a party can file further particulars or deny in a reply the vermin in the pleading must not be general, it must be specific as to facts. The settled law that a petitioner's obligation to plead particulars of fraud or falsification without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above. I adopt it as mine. Close of court. That's why allegations of non-compliance and corrupt practices are made, such as in the instant petition. The polling units, wards, or other places where those irregularities and malpractices are alleged to have occurred must be specifically pleaded. The petitioners have argued that the issue of non-compliance by the first respondent, its laws, guidelines, and relevant statutes is a universal complaint because it is an infraction against the Nigerian people and the Nigerian state. However, this contention of the petitioners is not in consonance with the requirement of the law as espoused in Belgore and Ahmed, PDP and INEC. This is more so as the petitioner's allegations of non-compliance is interwoven with allegations of corrupt practices in the same set of facts pleaded for both. In the instant case, the petitioner tendered the following documents, which have been listed in this judgment. However, a look at the entire petition shows that no single complaint was made by the petitioners in respect of any of those states as to make those exhibits relevant to the petitioner's case. For instance, in paragraph 72, which the petitioners referred in response to the objection, the petitioners have alleged that there was overvoting in the states of Oyo, Ondo, Taraba, Oshun, Kano, Rivers, Borno, Katsina, Kwara, Gombe, Yobe, and Niger states. However, the petitioners failed to specify the polling units where the overvoting took place, the total number of accredited voters, the total number of votes cast, and the number of votes to be deducted from the scores of the parties. Similarly, in paragraph 73, which was also referred to by the petitioners in their response to the objection, the petitioners have averred that based on the uploaded results, the votes recorded for the second respondent did not comply with the legitimate process for computation of the result and disfavored the petitioners, and listed the states of Rivers, Lagos, Taraba, Benue, Adama, Imo, Bauchi, Borno, Kaduna, Plateau, and other states of federation. But the petitioners failed to state the scores improperly computed and how they were disfavored. As regards the objection to exhibits PCE1 to PCE4, said to be 18,084 and 88 blood results downloaded from IRF and contained in 4 boxes, the petitioners have contended that the petitioners' request for the petitioners to specify the 18,088 polling units to which those blood reports relate is an impossibility because the results are unreadable. The details of most of the polling units are stated in PCD1 to PCD3, the expert report tendered by PW4. This contention of the petitioners is, however, misconceived. This is because the petitioners who claim that they could not specify the polling units in the 18,088 blood results because those results are unreadable are the same persons who have stated that the said polling units have been specified in the expert report of PW4, through whom the blood results were tendered. However, PW4 stated under cross-examination that the primary source of the data he used in producing his report was the IREF portal. He did not state how he was able to determine the particular polling units and the impacted votes, accredited voters, and the number of PVCs collected. As I earlier noted, PW4's report was concluded on 19th March 2023 before the petitioners filed this petition on 20th March 2023, which means the petitioners were aware of the polling units to which their complaints relate even before they filed the petition. So their theory of impossibility, which they invented around the 18,088 blood results, is misconceived and an obvious misadventure. Again, in paragraphs 7 and 8 of the petition, the petitioners admitted that they have agents in the polling units, and those agents signed and collected duplicate copies of the result sheets. Those paragraphs read as follows. Paragraph 7. The petitioner is a body corporate with perpetual succession and in sponsorship of the first petitioner and the conduct of the election thereof, acted through its members duly appointed as agents at all stages of the election, namely at the polling units, the ward collation centers, the local government collation centers, the state collation centers, and the ultimate collation center at the federal level in Abuja. Paragraph 8. In the conduct of the election, the agents duly appointed by the petitioners performed their assigned and statutorily designated roles at the election. These roles included observing and monitoring the process of arrival of election materials where they were supplied by the first respondent, and leading to and including the process of accreditation, voting, counting of votes, and announcement of the results of the election. These agents were the elections proceeded in due form upon the first respondent agents duly entering the results in the result sheets at the polling units, signed and collected duplicate copies of the result sheets. Having clearly admitted that their agents signed and collected duplicate copies of the result sheets, their contention that they are unable to determine the polling units from which the blood results emanated is untrue. In fact, this admission reinforces the need for the petitioners to specify all the polling units in respect of which they made complaints, since their agents were availed with copies of the results of the polling units. As regards the petitioners' contention that they have complied with paragraphs 4, 5C, and 41.8 of the first schedule to the Electoral Act 2022, I had earlier considered this argument of the petitioner while resolving the respondent objection to petitioner's pleadings, wherein we held that the provision of paragraph 4, 5C of the first schedule to the Electoral Act 2022 only relates to the front-loading of documents to be relied upon by the petitioners as their evidence during trial. It does not obviate the mandatory requirement for pleading materials as stated in paragraph 41.1d and 2 and 41.8 of the same schedule, so as to enable the adverse party to know the exact case he is to meet and to respond to them accordingly. As stated in our my earlier ruling, the reports which the petitioner stated they had detailed the polling units was not filed along with the petition, so as to afford the respondent the opportunity to respond to same, but was merely tendered at trial, by which time the respondents had no opportunity to respond. Since the petitioners have failed to specify in the petition the polling units to which exhibits PCA1 to PCA4, the 18,088 blood results relate, the said documents are clearly inadmissible. Said exhibits hereby discountenance and expunged from the record. We now go to petition objections to the respondent's documents. In the course of trial, the petitioner also objected to the documents tendered by the first and second and third respondents at the hearing of the 4th of July 2023. The first respondent had tendered exhibits RA1, RA2, RA3, RA4, F5, 6, and 7 through its sole witness, Dr. Lawrence Bayode, a deputy director in the ICT department of the first respondent, who gave evidence as RW1. Of those documents, the petitioners had objected to the admissibility of exhibits RA1, RA2, RA6, and RA7. Similarly, at the hearing of the 5th of July 2023, the petitioners had objected to all the documents tendered by the second and third respondents from the bar and through their sole witness, Senator Michael Opeyemi Bamidele, who testified as RW2. The petitioners had reserved their reasons for the objections to be adduced at the stage of final address. Pursuant to the order of this court, that parties should file separate addresses on their objections. The petitioners have filed separate addresses in support of their objections to the documents of the first respondent and those of the second and third respondents. The written address in support of the objection of the first respondent's documents was filed on 23rd July 2023, while that in support of the objection to the second and third respondent documents was filed on 20th July 2023. In the written address in support of the petitioner's objection to the first respondent document, Dr. Olivier Uzoku, learned senior counsel for the petitioners, essentially raised the sole issue of whether, having regard to the pre-hearing report of 23rd May 2023, paragraph 41, sub 3 of the first schedule to Electoral Act 2022 and other relevant provisions of the Act and decided cases, exhibits RA 1, 2, 6, and 7 are inadmissible and liable to be exchanged from the evidence. Similarly, in the address in support of the objection to the second and third respondent documents, the petitioners raised the sole issue of whether, having regard to the said pre-hearing session report and paragraph 41(3) of the first schedule and decided cases, the documents tendered by the second and third respondents are inadmissible and liable to be expunged from evidence. Plaintiff pointed out that Exhibit RA1 is a private document emanating from the third respondent and argued that in the absence of the narrow exceptions to the maker of the document, being the person to tender the document, the witness of the first respondent, that's RW1, cannot tender same in evidence. He relied on Main Street Bank Limited and General Steel Mills Others Limited. National Council also submitted that Exhibit RA2 is inadmissible because the first respondent cannot appropriate at the same time, since Exhibit RA2, the first respondent is trying to deny another letter received by it from the fourth respondent on 15 July 2022, which he had also certified. So we'll just go direct to the resolutions. So by virtue of the provisions of Section 102B of the Evidence Act 2011, public documents include public records kept in Nigeria of private documents. In the case of Onwuzurike and Idoziem and others, where the Supreme Court by Onogen JSC held, as he then was, held that a private document sent to the police form part of the record and of the police, and is consequently a public document within the provisions of Section 109 of the Old Evidence Act, now Section 102 of the Extant Evidence Act 2011. It's also tried that a public document duly so satisfied is admissible in evidence, notwithstanding that it is not tendered by the maker. Indeed, a certified true copy of a public document can be tendered by a person who is not a party to the case. See the case of Maranro and Adebisi, Dagashan Bulama, Mustafa Ketima, and others versus Al-Haji Bukar of Customs. Exhibits RA1 and RA2, being in the public record of the first respondent, are public documents and are therefore admissible in evidence, having been certified by the first respondent under Section 104 of the Evidence Act 2011. On the petitioner objection to Exhibits RA6 and RA7, the record of proceedings of this court of 4th July 2023 shows that contrary to the assertion of the petitioners, the said Exhibits RA6 and RA7, which are the cloud trail log and certificate of compliance to Section 84 of the Evidence Act respectively, were not tendered from the bar, but through RW1. Indeed, the record shows that the petitioners consented to the said documents being taken as read and demonstrated. They therefore have no hesitation in discountenancing the petitioner's objection to those documents. On the whole, the petitioner's objection to Exhibits RA1, RA2, RA6, and RA7 tendered to respondents and meritorious, it is hereby overruled. Now go to objection to the petition objection to the second and third respondents' documents. We consider the the resolution of that objection on the petition objection to Exhibits RA8 and RA9. An examination of the petition shows that in paragraph 28, they have challenged the second respondent qualification to contest the election on the ground that he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division. As rightly submitted by the second and third respondents, they have countered this allegation of the petitioners in paragraphs 46 to 53, and particularly pleaded in paragraph 50 that the United States of America, through its embassy in Nigeria, had by a letter dated February 4, 2003, addressed to the then Inspector General of Police, confirmed that upon their record checks of the Federal Bureau of Investigation, National Crime Investigation Center, NCIC, a centralized information center that maintains records of every criminal arrest and conviction within the United States of America. There were no record of any form of criminal arrest, warrants against the second respondent. The respondents shall found and rely upon a copy of the said letter of February 4, 2023. Done by Michael M. Bonham. Yes, the date is wrongly stated, corrected. From the foregoing, it is obvious that issues were joined by the parties when the indictment alleged by the petitioners and Exhibits RA8 and RA9 are clearly relevant. As for the argument of the petitioner over the custody of the documents, Exhibit RA8 is a letter of inquiry written by the Inspector General of Police to the Consulate General of the United States Embassy in Nigeria, inquiring as to whether the second respondent had any criminal record in the United States of America, while Exhibit RA9 is the reply to Exhibit RA8 by the United States Embassy in Nigeria. Both letters form part of the record of the Nigeria Police and are therefore public documents under Section 102B of the Evidence Act. Certification by the Nigeria Police Force is a confirmation that Exhibits RA8 and RA9 are true copies of those documents which are in their custody. Onwuzurike and Idoziem, Abaje and Koka. With regard to the petition objection to the relevance of Exhibit R10, the record shows that the petitioner's challenge to the qualification of the second respondent was confined to allegations of double nomination of his running mate, the third respondent, and the alleged fine of the second respondent of the sum of $460,000 by a United States court. The educational qualifications of the second respondent were never challenged by the petitioners in this petition. It was the second and third respondents who introduced the educational qualifications of the second respondent in their reply, and the petitioner have not joined issues with the second and third respondents in their reply to the second and third respondent reply. That a court of law adjudicates only on matters over which parties are in dispute. The Adedeji and Olosho and another Trade Bank PLC versus Benelux Nigeria Limited. Since there is no controversy or dispute between the parties as it relates to the second respondent educational qualifications, Exhibit RA10 is not relevant to determination of this petition, hereby discountenance. Our examination of Exhibits RA11 to RA16, which are data pages and visa pages in the second respondent Nigerian passport, show that contrary to the assertion of the petitioners that the documents are not relevant, the petitioners have alleged in paragraph 28 to 32 of the petition that the second respondent was fined $460,000 for an offense involving dishonesty, namely narcotics trafficking, and in response to this allegation, the second and third respondents have denied same in paragraph 46 to 53 of their reply, and specifically pleaded those documents in paragraph 52 of their reply to the petition to show that the second respondent enjoyed an unrestricted right of ingress and egress to the United States of America, and up till now, he still enjoys an unimpeded right of access to the United States of America. It is therefore our considered view that Exhibits RA11 and RA16 are relevant to these proceedings. It is no objection to them, hereby discountenance. As for Exhibits RA17 and RA18, the petitioner's reason for objecting to them has nothing to do with the admissibility of the documents. The second and third respondents, having raised objection to the first petition's local standard to present the petition in paragraphs 1A to M of their reply to the petition. However, we have already considered and determined the issue of the petitioner's local standing whilst resolving the respondents' preliminary objections. We have already resolved them in favor of the petitioners. Therefore, this objection has been overtaken by our ruling on the preliminary objection. On the petitioner contention that Exhibit RA19, the report of the committee on the location of the federal capital Nigeria, is not relevant, we have examined the pleadings and the said exhibit. It is apparent to us that while the petitioners have averred in paragraph 81 of the petition that a presidential candidate must score 25% of the votes in FCT before he can be declared and returned elected, the second and third respondents have averred in paragraph 86 of their reply that the FCT does not enjoy a special status over the other states of the Federation, and that Abuja is still inhabited by Nigerians who are deemed equal to Nigerians in any other part of Nigeria, and residents of Abuja are not conferred with any privilege and advantage that is not accorded to citizens of other communities or states in Nigeria. We are therefore of the view that facts have been pleaded which renders Exhibit RA19 relevant and admissible. On the petitioner's objection to the admissibility of Exhibit RA22, we observe that the document is the same as Exhibit RA2, which we have already found to be admissible, having been certified by ANIC as a copy of document in their possession. Standard of Exhibit RA22, which is not even certified, is therefore a surplusage, hereby discountenance. With regard to the objection to admissibility of Exhibits RA24 and RA25, which are CTCs of pages 28 and 29 and 27 of Nigerian Tribunal newspapers, respectively. The reasons advanced for the objection of the petitioners are not legal grounds for challenging admissibility of a document. We have no hesitation in discounting the objection, contrary to the arguments of the second and third respondents' counsel that Exhibit RA27, the ECOWAS preliminary declaration, is a private document. The said document forms part of the official record of the Economic Community of West African States, ECOWAS, an official body established under the ECOWAS Treaty. An agreement made by member states of the ECOWAS community, and the treaty was signed by heads of states and government of the 16 member states. is undoubtedly a public document within the meaning of Section 102 of the Evidence Act 2011. However, we observe that Exhibit RA27 is not certified as required by Section 104 of the Evidence Act to render same admissible. Not being so certified, Exhibit RA27 is hereby expunged from the record. As for the objection to Exhibit RA28 being the American Bar Association membership card of RW2, which was tendered by RW2 under cross-examination by the fourth respondent, it's clear to us that the document was neither pleaded nor listed or referred to in the statement of RW2, as rightly argued by the petitioners. Exhibit RA28 is inadmissible. Accordingly, it is hereby expunged record. Now we go to the merit of the petition. Having disposed of the various objections to witnesses and to some of the documents tendered in this petition, we now proceed to consider the merit of the petition. The parties filed, exchanged, and adopted their respective final written addresses starting with the respondents. The respective final addresses of the first, second, and third, and fourth respondent were filed on the 14th July 2023, respectively. On the 23rd of July 2023, 20th July 2023, and 23rd July 2023, the petitioners filed 3 separate final addresses in response to the final addresses of the first, second, and third, and fourth respondents, respectively. In reaction to the petitioners' final addresses, the first, second, and third and fourth respondents filed their reply addresses on 28th July 2023, 21st July 2023, and 28th July 2023, respectively. The first respondent and the second and third respondent also filed lists of additional authorities on the 28th and 31st of July 2023, respectively. On the 1st of August 2023, the parties adopted their respective final addresses. In his adopted final written address, Learned Senior Counsel for the first respondent, A.B. Mahmoud S.N., distilled the following 5 issues for determination. A. Whether having regard to the provision of Section 131 and 137 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the evidence before the court, the second and third respondents were qualified to contest the presidential election 25th February 2023. B. Having regard to Section 47, subsection 2 and 3 of the Electoral Act 2022, paragraph 38 and 92 of the regulations and guidelines for the conduct of the election 2022, the inability of the first respondent to transfer or transmit the results of the presidential election to the IRF portal real time amounted to non-compliance to Electoral Act, whether such non-compliance substantially affected the outcome of the election. C. Whether by the totality of evidence adduced, the petitioners have proven that the election of the second respondent was invalid by reason of corrupt practices and non-compliance with the provisions of the Electoral Act 2022. D. Whether in the absence of any proof of lawful and unlawful votes to be added to the scores of the petitioners and or unlawful votes to be deducted from the second respondent's scores at the election, the petitioners have proven that the second respondent was not elected by a majority of lawful votes cast. E. Whether having regard to the declared results of the election and the provision of Section 134, subsection 2B of the Constitution of the Federal Republic of Nigeria 1999 as amended, the second respondent ought to have been returned as duly elected after having scored the highest number of votes cast with 25% of the votes cast in over 2/3 of the state's federation. The Learned Senior Advocate for the second and third respondents, Chief Wale Olanipekun, formulated the following 4 issues for determination. 1. Having regard to the relevant provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, salient provisions of the Electoral Act 2022, judgment of Federal High Court, and FACA BJCS 1454/2022, Labour Party and INEC delivered on 23rd January 2023, which is Exhibit X1, as well as admissible evidence on record, whether the election of the second respondent into the office of President of the Federal Republic of Nigeria on 25th February 2023 was not in substantial compliance with the principles and the provisions of the Electoral Act 2022. 2. In view of the clear provisions of the Constitution of the Federal Republic of Nigeria 1999, the Electoral Act 2022, and plethora of judicial precedents on the criteria for qualification of candidates for election to the office of President, coupled with the unreported decision of the Supreme Court in SC/CV/501/2023, People's Democratic Party vs. Independent National Electoral Commission, INEC, delivered on 26 May 2023, Exhibit RA23, whether the second and third respondents were or are not eminently qualified to contest the presidential election of 25th February 2023. 3. Upon a combined reading of sections 134 and 299, as well as other relevant sections of the Constitution of the Federal Republic of Nigeria 1999 as amended, Section 66 of the Electoral Act 2022 and other relevant statutes, whether the second respondent has not satisfied the necessary constitutional and statutory requirements to be declared winner of the presidential election of 25th February 2023 and returned as President of the Federal Republic of Nigeria. 4. Considering the constitutional petition and the task evidence adduced, whether this honorable court can accede to the reliefs being claimed by the petitioners. Prince L.O. Fabemi SN, Senior Counsel for the fourth respondent, also nominated 4 issues for termination as follows. 1. Whether having regard to the issues joined and the evidence led on the nomination of the third respondent as vice presidential candidate of the second respondent and the annulled civil forfeiture of the alleged civil forfeiture of the sum of $460,000 to the United States by order of the District Court in case number 93C4483. The petitioners have established that the second respondent was not qualified to contest the presidential election held on 25th February 2023 as provided for in the Constitution of the Federal Republic of Nigeria 1999 as altered. 2. Whether having regard to the relevant and admissible evidence led by the parties, the conduct of the presidential election held on 25th February 2023 election was vitiated by non-compliance that was substantial enough to have affected its outcome and justified nullification of the election as envisaged by the applicable provisions of the Electoral Act 2022. 3. Whether the burden of proving that first petitioner and not second petitioner scored majority of lawful votes cast in each of at least 2/3 of all states of the Federation and the Federal Capital Territory to be declared and returned as the winner of the presidential election held on 25th February 2023 has been discharged by the petitioners. 4. Whether having regard to the totality of the evidence led by the parties and the applicable law, the petitioners are entitled to succeed on any of the relief sought in the petition at all, or that the petition ought to be dismissed in favor of the respondent. On the part of the petitioners, their lead senior counsel, Dr. Levi Uzoku SN, distilled the following 3 issues in the petitioner's final address in response to the final address of the first and fourth respondents. 1. Whether the second and third respondents are qualified to contest the presidential election by reason of the unchallenged facts and circumstances arising under Section 137, subsection 1D, 142, subsection 1 and 2 of the 1999 Constitution, Section 35 of the Electoral Act 2022. This petition. 2. Whether from the documentary evidence before the Honorable Court read and examined together with the unchallenged expert and technical evidence of the petition witnesses, the petitioners proved that the non-compliance by the first respondent with the relevant provisions of the Act 2022 and the subsidiary legislation made thereunder substantially affected the outcome of the questioned presidential election held on 25th February 2023. So in response to the second and third respondent final address, the petitioners adopted issues 1 to 3 of the issues for examination with the earlier filed on 18th May 2023 during the hearing session. These are: 1, whether the second respondent at the time of the presidential election held on 25th day of February 23 was not disqualified to contest the said election by virtue of the provisions section 1371D of the Constitution of the Federal Republic of Nigeria amended. 2, whether the third respondent at the time of the presidential election held on 25th February 2023 was qualified to contest the said election as the vice president candidate to the second respondent, and if answered in the negative, whether this did not invalidate the qualification of the second respondent to contest the said election. 3, whether the presidential election held on 25th February 2023, wherein the second respondent was declared and returned by the first respondent as the winner, was not invalid by reason of non-compliance with the provisions of the Electoral Act 2022 and any guidelines and regulations for the conduct of the elections 2022 made pursuant to the Act. From the pleadings, the evidence adduced, and the submissions of counsel of the parties, it is a considered view that the following are the issues which will effectively determine this petition. 1, whether having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria 99 as amended, Section 35 of the Electoral Act 2022, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 25th February 2023. 2, whether having regard to the evidence adduced by the parties, the petitioners have established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. 3, whether from the totality of the evidence adduced, the petitioners have proven that the presidential election held on 25th February 2023 was invalid by reason of corrupt practices. 4, whether from the evidence adduced by the petitioners have established that the second respondent was not duly elected by a majority of lawful votes cast at the election. Well, we stated earlier, we have summarized the submissions of counsel. We didn't want it of reading them out. The first issue is whether, having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria as amended, Section 35 of the Electoral Act, and the evidence before the court, the second and third respondents were qualified to contest the presidential election of 25th February 2023. Well, I think issue of qualification on this issue has been resolved in petition number 4. It's the same issue that has been raised here. So we stand by our resolution, this issue. The only exception is the allegation on the issue of the second allegation made by the petitioners in ground 1, which is contained in paragraphs 28 to 32 of the petition, is that the second respondent is disqualified from contesting the presidential election because they stated in paragraph 28 of the petition as follows. The Petitioner further pleaded that the second respondent was also at the time of the election not qualified to contest for election to the office of president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, imposed by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C4483 between United States of America plaintiff versus funds in account of 263226 held by First Heritage Bank in the name of Bola Tinubu, funds in accounts 39483134, 39483396, 4650279566, held by Citibank NA in the name of Bola Tinubu or Compass Finance and Investment Company. Funds in accounts number that are held by Citibank International in the name of Bola Tinubu defendants. The petitioners have pleaded and relied on the order of the U.S. Court in Exhibit P5, which they tendered from the bar and which was subsequently identified by PW2 and PW12 in their evidence earlier summarized. The petitioners have centered their contention on the provisions of Section 137, subsection 1D of the 1999 Constitution, which reads as follows. A person shall not be qualified for election to the office of president if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or sentence of imprisonment or fine or any offense involving dishonesty or fraud by whatever name called, or for any other offense imposed by him by any court, tribunal, or substituted by a competent court, by competent authority, or any other sentence imposed on him by such court or tribunal. A careful examination of the above provision shows that the operative words of that paragraph of the section are sentence, imprisonment, or fine, and for any offense. Black's Law Dictionary, 6th edition, at page 1081, defines offense as, quote, a felony or a misdemeanor, a breach of the criminal laws, violation of law for which penalty is prescribed. The word offense, while sometimes used in various senses, generally implies a felony or a misdemeanor, infringing public as distinguished from mere private rights, as unpunishable under the criminal laws, though it may also include the violation of a criminal statute, which the remedy is merely a civil suit to recover the penalty, an act clearly prohibited by the lawful authority of the state, providing notice through public laws, close of court. Also, the Supreme Court, in the case of Abdullahi Umar and the state, held that an offense is an act which is clearly prohibited by law and which may be a crime or a civil offense. Sentence, on the other hand, has been defined by the same Black's Law Dictionary at page 1362 as follows. The judgment formally pronounced by the court or judge upon the defendant after his conviction in a criminal prosecution, imposing the punishment to be inflicted, usually in the form of a fine, incarceration, or probation. Again, this court also defined sentencing in Yakubu and the state as follows. A judicial determination of a legal sanction to be imposed on a person found guilty of an offense. It means the prescription of a particular punishment by a court to someone convicted of a crime. It is discernible from the above that the fine referred to in paragraph E of section 137(1) quoted above is one which emanates from a sentence for a criminal offense involving dishonesty or fraud. The words for imprisonment or fine also presupposes that the fine envisaged under the section is one which is imposed as an alternative to the imprisonment. In other words, section 137, subsection 1D relates to sentence of death or sentence of imprisonment or fine imposed as a result of a criminal trial conviction. Indeed, in considering the offense that can amount to disqualification under section 1371 of the Constitution, the Supreme Court held Action Congress versus ANIC as follows. The disqualification in Section 137, subsection 1 clearly involves a deprivation of right and a presumption of guilt or embezzlement or fraud in derogation of the safeguards in Section 36, subsection 1 and 5 of the Constitution. The trial and conviction by a court is the only constitutionally permitted way to prove guilt, and therefore the only ground for the imposition of criminal punishment or penalty for the criminal offenses of embezzlement or fraud. Clearly, imposition of the penalty of disqualification for embezzlement or fraud solely on the basis of an indictment for those offenses by an administrative panel of inquiry implies a presumption of guilt, contrary to Section 36 of Section 5 of the Constitution of the Federal Republic of Nigeria 1999, whereas conviction for offenses and imposition of penalties and punishment are matters appertaining exclusively to judicial power. See also the cases of Amici and Anis Omuwaye versus Attorney General of State, Abdul Karim and others versus Shinkafi. A careful perusal of P5 relied upon by the petitioners show that the case number 193 CV04483 was in the civil docket of the U.S. District Court, Northern District of Illinois, and it was a civil forfeiture proceeding against funds in specified accounts with First Heritage Bank and Citibank N.A. Exhibit N5 is actually an action in rem against the funds with First Heritage Bank and Citibank. It is not an action in personam against the second respondent. In Jonathan versus Federal Republic of Nigeria, citation supplied, the Supreme Court held in inter alia that Section 17 of the Advanced Fee Fraud and Other Related Offences Act 2006 provides for the power to make an order of forfeiture without conviction or for an offense, and that an order of forfeiture under the section shall not be based on conviction for an offense under the Act or any other law. The Apex Court further held that there was no need to prove any crime in forfeiture property under Section 17 of the Advanced Fee and Other Related Offences Act. A civil forfeiture is a unique remedy which rests on the legal fiction that the property, not the owner, is the target. Therefore, it does not require conviction or even a criminal charge against the owner, as it is not a punishment, nor is it for criminal purposes. See also the cases of Lawari Furnitures and Baths Limited versus Federal Republic of Nigeria, Alison Madueke versus ESCC. From the legal definitions and judicial authorities cited above, it is clear that the sentence of imprisonment or fine for any offense involving dishonesty or fraud envisaged in Section 137, subsection 1D of the Constitution is one imposed upon a criminal trial and conviction. In the instant case, the petitioners have failed to show evidence that the second respondent was indicted or charged or arraigned, tried and convicted, and was sentenced to any term of imprisonment or fine for any particular offense. On the part of the second and third respondents, they have contended that the second respondent was never fined for any offense and has no criminal record in the United States. In proof of their assertion, they have tendered exhibits RA8 and RA9 from the bar and called RW2 to give evidence and identify the said exhibits as documents he referred to in his adopted statement of oath of 12 April 2023. In paragraph 45 to 52 of his statement on oath, RW2 has stated that the second respondent was never convicted or fined for any criminal offense in the United States as alleged by the petitioner. In particular, RW2 stated as follows in paragraph 46, 47, and 49. 46 say, in case number 93C4483 at the United States District Court, Northern State District of Illinois, Eastern Division, which was pleaded by the petitioners. 1, no criminal charge was filed against the second respondent. 2, the second respondent was not arraigned and did not take or make a plea to any count in the charge of allegations of crime. 3, the second respondent did not go through a criminal trial. 4, the second respondent was not convicted of any crime or any criminal activity. 5, no sentence of imprisonment was imposed on the second respondent. 6, no sentence of fine was imposed on the second respondent. 7, no form of sentence was imposed on the second respondent. 8, case number 93C4483 was a civil suit in respect of which the court exercised civil jurisdiction under 18 U.S.C. 981 and 28 U.S.C. 1345 and 1355. In paragraph 47, he said, I also note that in case number 93C4483 at the United States District Court, Northern District of Illinois, Eastern Division, no impersonum criminal sentence was imposed on the second respondent. 49, the second respondent was not convicted in case number 93C4483, United States District Court, Northern District of Illinois. The United States of America, through its embassy in Nigeria, had, by a letter dated February 4, 2003, addressed to the then Inspector General of Police, confirmed that upon the record checks for the Federal Bureau of Investigations, National Crime Investigation Center, NCIC, the Centralized Information Center that maintains the record of every criminal arrest and conviction within the United States of America, there were no records of any form of criminal arrest, warrants against the second respondent. I shall rely upon a copy of the said letter of February 4, 2023, signed by Michael M. Bonner. Under cross-examination by the fourth respondent, RW2 has stated that as a practicing attorney in the United States, he knows that there cannot be a conviction unless there is an indictment. He also stated that exhibits RA8 and RA9 gave the second respondent a clean bill of health as far as criminal conviction is concerned. When cross-examined by the petitioner's counsel, RW2 has stated that the American court relied on Section 981 of the American Money Laundering Law, which is a civil, and not Section 982, which is criminal, and which the petitioner stated in their petition. He further stated that in the US, even a minor traffic infraction will be reported, so that if someone has a criminal record, the general record will show it. He added that a general search was conducted in respect of the second respondent. A look at exhibits RA8 and RA9 tendered by the second and third respondents showed that upon receipt of exhibits RA8 written by Nigeria's Inspector General of Police to the Consular General of the United States Embassy in Nigeria, inquiring of the criminal record of any of the second respondents, the U.S. Embassy had replied with the exhibit RA9 and stated as follows. Quote, in relation to a letter dated February 3, 2003, reference number SR 3000, IGP SEC, ABJ, volume 24, 289, 87, regarding Governor Bola Ahmed Tinubu, a record check of the Federal Bureau of Investigation, National Crime Information Center, NCIC, was conducted. The results of the checks were negative for any criminal arrest records, warrants or warrants for Bola Ahmed Tinubu, POB 29, date of birth, March 1952. For information of your department, NCIC is a centralized information center that maintains the record of every criminal arrest and conviction within the United States and its territories. Apart from the above, Section 249 of the Evidence Act 2011 has stipulated how previous criminal conviction outside Nigeria can be established. Section 249, subsection 1 and 2 provides a previous conviction in a place outside Nigeria may be proved by the production of a certificate purporting to be given under the hand of a police officer in the country where the conviction was had, containing a copy of the sentence or order and the fingerprints of the person or photographs of the fingerprints of the person so convicted, together with evidence that the fingerprints of the person so convicted are those of the defendant. 2. A certificate given under subsection 1 of this section shall be prima facie evidence of all facts set out in it, without proof that the officer purporting to sign it did in fact sign it and was empowered to to do so. It is instructed to observe that when cross-examined by the fourth respondent, PW1 had admitted that there was no certificate under the hand of a police officer in the United States of America where a crime was alleged to have been committed by the second respondent. It is significant to state that this petition is a declaratory action in which the petitioners are seeking inter alia that this court declare the second and third respondents as unqualified to contest the election. The petitioners who have made the allegation have the burden to prove the allegation on the strength of their own case and not on the weakness of the respondents. The Okereke vs. Umahi, Menike vs. PDP, Omushore vs. Rebushola, Ucha and Elechi. The petitioners have evidently failed to establish the allegation that the second respondent is disqualified from contesting the presidential election under Section 137, subsection 1D of the 1991 Constitution because he was fined the sum of $460,000 by District Court, Northern District of Illinois. As shown above, the order of forfeiture in Exhibit PA5, on which the petitioners have relied, does not qualify as a sentence of fine for an offense involving dishonesty or fraud within the contemplation of Section 137 sub D of the 1999 Constitution. As regards whether paragraph E of Section 137(1) will be read together with paragraph D of that subsection, the settled rule of interpretation of the Constitution or statute is that where the court is faced with two or more differing provisions over the same subject matter, the judicial attitude is to treat the special provision as overriding the general provision on the principle that by enacting a separate provision for a part of the general class intends that the said part shall not be treated the same with the general class. The Uchuku Nada versus Attorney General Anambra State, Martin Roida and others versus Major and Co. Nigeria Limited, but FMBN versus Olo. In both paragraph D and E of Section 137, subsection 1, a sentence for the offense of involving dishonesty is mentioned, but in paragraph E, a limitation of 10 years has been introduced. Then it means, in respect of the sentence for offense of dishonesty, the two paragraphs must be read together. That for conviction and sentence for an offense involving dishonesty, it must be within a period of less than 10 years before the date of the election, in order for such a conviction and sentence to be used for disqualifying a presidential candidate from contesting the election. It is also a cardinal principle interpretation of the Constitution that relevant provisions must be read together and not disjointedly. Abegunde and the State House of Assembly. From all the foregoing, it is clear that having regard to the provisions of Section 137 of the Constitution of the Federal Republic of Nigeria 1999 as amended and the evidence laid before this court, the second respondent was not disqualified from contesting the presidential election held on 26 February 2023. Consequent issue 1 is hereby resolved against the petitioners and in favor of the respondent. Issue 2 is whether, having regard to the evidence adduced by the parties, the petitioners has established that there was substantial non-compliance with the provisions of the Electoral Act 2022 and that the non-compliance substantially affected the results of the election. Then we shall skip the submissions of counsel. Well, the appropriate starting point for the resolution of this issue is to first consider the objection of the first respondent to ground 2 of the petition, which they raised at preliminary stage, but which we deferred to this stage because it touches on the substance of the petition. The first respondent objection is that the petitioners are stopped from relitigating the issue contained in paragraph 2, paragraphs 33 to 79, as well as reliefs 5.1 and 2 of the petition, as is relates to electronic transmission and collation of the election results, in view of the subsequent judgment of the Federal High Court in suit number FHC ABS CS 1454-2022, Labour Party Independent Electoral Commission, delivered 23rd January 2023. A certified true copy of which they attached to their petition as Exhibit A, and which was later tendered in evidence at trial as Exhibit X1. The first respondent particularly referred this court to paragraph 55 and 74 of the petition and submitted that the facts alleging non-compliance with the Electoral Act, which are set out in paragraph 33-79 of the petition, are hinged on the same issue of electronic transmission of results, which was resolved against the second petitioner in the said suit number FHC ABSC 1454-2022, to the effect that there is no mandatory requirement for the first respondent to electronically transmit results of the election. Reliance was placed on Begin and others was Oriare, Oyeroba, and another was Laupa. An examination of petitioner's petition and Exhibit X1 shows that in their petition, specifically paragraph 37, 45, and 45, the petitioners have averred as follows. The petitioners aver that at the conclusion of the election and at each polling unit, the presiding officer was mandatorily required to electronically transfer the result of the polling unit directly to the collation system of the first respondent. In addition, the presiding officer was also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent's result viewing portal, RF, in real time. 45. The petitioners aver that apart from the importance of the beavers in the capture of accreditation at polling unit in an election, the beavers is also mandatorily to be used in the process of uploading the information or data imputed into it by the first respondent's presiding officer at each polling unit, who shall, upon completion of voting and due recording and announcement of results, 1. Electronically transmit the result of the polling unit directly to the collation system as described by the first respondent. 2. Use the beavers to upload or a scanned copy of the Form EC8A to the annual result viewing portal, RF, as prescribed by the first respondent. And 3. Take the beavers and the original copy of each of the forms in tamper-evident envelope to the registration area reward collection officer in the company of security agents. The polling agents may accompany the presiding officer to the registration area reward collection center. In Exhibit X1, the certified true copy of the judgment of the Federal High Court in suit number FHC ABJ CS 1454-2022 Supra, which the first respondent is contending to constitute estoppel to ground 2 of this petition. The sole question presented for determination in the originating summons is as follows. Whether, having regards to combined effect of sections 47.2, 52, 64, 65, and 62.1 and 2, and other relevant provisions of the Electoral Act 2022, the respondent can still insist on manual collation of results in the forthcoming general election. Upon determination of the above questions, the plaintiff, which is the second petitioner herein, sought for the following reliefs. 1. A declaration that the respondent has no power to opt for manual method other than electronic method provided for by the relevant provisions of the Electoral Act. 2. An order of this honorable court directing or compelling the respondent to comply with the Electoral Act 22 on electronic transmission of results in the forthcoming general election. In its judgment in Exhibit X1, the Federal High Court held as follows. In view of the foregoing, can the act of the defendant in collecting and transferring election results manually in the forthcoming 2023 general election be said to be contrary to the relevant provisions of the Electoral Act 2022? The answer can only be in the negative, as there is nowhere in the above cited sections where the Commission or any of its agents is mandated to only use an electronic means in collecting or transferring of election results. If any, the Commission is only mandated to collect and transfer election results and number of accredited voters in a way or manner deemed by it. In view of the above, I'm finding that by the provision of sections 52 and 65 of the Electoral 2022, the correct interpretation of said statute is that the defendant, Independent National Electoral Commission, is at liberty to prescribe the manner in which election results could be transmitted and are so called. Consequently, this matter is hereby dismissed. Clause of court. It is tried law that for a judgment of a court to constitute estoppel in a subsequent action, it must have finally decided the same issue in contention between the same parties or their previous. The Anchorage Leisures Limited and others versus Eco Bank Nigeria Limited. And Adebayo versus Babalola and others. From the averments contained in the petitioner's petition, which I have earlier reproduced above, it is clear that the petitioner allegation of non-compliance averred in paragraph 2 of the petition is hinged on the contention that ANIC was mandatorily required to electronically transmit or transfer the results of the polling units directly to the collation system of the first respondent, and also mandatorily required to use the beavers to upload a scanned copy of the Form EC8A to the first respondent result viewing portal, IRF, in real time. First, it is evident that in both this petition and in Exhibit X1, the parties are the same. In that second petitioner herein was the sole petitioner plaintiff in Exhibit X1, while the first respondent herein was the sole defendant in Exhibit X1. Secondly, from the above referred to averments in this petition and the relief sought by the petitioner in Exhibit X1, it is clear that the issue in both cases is whether the first respondent herein is mandatorily required to electronically transmit or transfer election results from the polling unit direct to the collation system. With the judgment of the Federal High Court in Exhibit X, the excerpt of which has been reproduced above, it is evident that the Federal High Court had decided the issue against the petitioners herein by holding that the first respondent cannot be compelled to electronically transmit election results. There is no evidence before this court that the second petitioner against whom the judgment in X1 was given has appealed against that decision. It is settled law that unappealed decision of the court remains subsisting and binding on the parties. The Abba versus Abba Aji, Jegede and INEC, Alexander and others versus Lone Star Drilling Company Limited. It is also tried that the doctrine of issue established is that where an issue has been decided by a competent court, the court will not allow it to be relegated by the same or different parties. It is also pertinent for us to state that in the final address of the first respondent, our attention was drawn to the recent decision of the Lagos Division of this court in appeal number CA/LAG/CV/332 2023, APC and Labour Party and 42 others, wherein this court set aside the decision in suit number FHC/L/CS/370/23, Labour Party and others versus ANIC. Another case, forum shopped by the second petitioner at the Lagos Division of the Federal High Court after losing at the Abuja Division of the same court in Exhibit X1. In the judgment in appeal number CALG-CV-332-2023, this court had upheld the decision of the Federal High Court in Exhibit X1 and construed same against the petitioners as issue estoppel in relation to the petitioner's contention which they are making in this petition that ANIC is mandatorily required to electronically transmit election results. By virtue of Section 122, subsection 2 of the Evidence Act, this court is entitled to take judicial notice of the decision in appeal number CALG-CV-332-2023, APC versus Labour Party and 42 others. Not only that, this court is by the doctrine of precedent bound by that decision. Since the above judicial pronouncements have decided that under the Electoral Act and Admin Regulation guidelines for the conduct of elections, the first respondent cannot be compelled to electronically transmit election results. The petitioners are clearly stopped by those decisions from contending in ground 2 of this petition that the first respondent is mandatorily required to electronically transmit the election results to the election system. As a court of first instance, this petition, we shall, notwithstanding our above finding, proceed to determine the merit of ground 2 of the petition relating to non-compliance. It is observed that in their petition, the petitioners have alleged the same set of facts in paragraph 33 to 79 as constituting both non-compliance and corrupt practice. On a careful perusal of the petition, however, it seemed to us that the allegations of non-compliance are contained in paragraph 33 to 56 and 59 of the petition, while specific allegations of corrupt practice were made in paragraph 60 to 78, even though them were also founded on the same facts of non-compliance alleged by the petitioners. The gravamen of the petitioner allegations of non-compliance are as encapsulated in paragraphs 37, 45, 50, 51, and 55 of the petition, which are reproduced below. I have produced. The respondents, particularly the first respondent, denied the allegations of non-compliance made by the petitioners in their respective replies to the petition. In particular, the first respondent denied that there was any collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer, and stated that the prescribed mode of collation of results is as stipulated in paragraph 50 to 55 of the regulations and guidelines for the conduct of elections. He further stated that the prescribed mode of collation was manual collation of the various forms EC8A, EC8B, EC8C, EC8D, and EC8E of the presidential election. See paragraph 31 of the first respondent's reply. He also stated that the BVAS is designed to upload the accreditation data at the end of the accreditation process and transmit the result of the election at a polling unit through the e-transmission system, which is uploaded to the first respondent's result viewing portal, IREF. The first respondent further averred that the upload of data or images captured and automatically restored on the BVAS device requires data service, and where there is no such data service, where the service is poor, the BVAS service is designed to work offline, and the upload of data will occur when data service is available. He also stated that polling unit results were duly uploaded on the first respondent e-transmission system by the respective presiding officers at the end of the election, but some of the results were not visible on the RF portal due to the technical glitch experienced on the election day. In specific response to the petitioner's allegation of failure, refusal, and neglect to instantly transmit and upload the results electronically from the BVAS to the RF, the first respondent stated in paragraph 55, Romans 7 and 10 as follows. Immediately after the election of 25 February 2023, polling unit results were uploaded and received by the e-transmission system whilst using the BVAS. There was a temporary failure of communication between the e-transmission system and the IRF portal for the presidential election. In this regard, the e-transmission system returned an HTTP 500 error, which is an application error such that transmitted results, though received on the in-transmission application hosted on the AWS, the in-transmission could not organize and push the results instantly to the presidential module on the RF portal because it could not map the results uploaded for the presidential election to any state. The first respondent pleads and shall rely on the AWS CrowdTrail logs indicating patches deployed to fix the error from technical glitch on the election day. Upon resolution of the HTTP 500 error, the results which were delayed in the e-transmission system were eventually organized and pushed to the RF portal. The results are available as generated in their original form from the polling unit using the BVAS. The first respondent stated that the technical glitch did not in any way affect the result of the presidential election. However, in paragraph 37 of their reply to the first respondent reply, the petitioners denied that there was any technical glitch experienced on election day as contended by the first respondent, and stated that the failure of the first respondent to upload the presidential election results using the beavers to the average was a ploy to manipulate the actual results of the election. As indicated in their pleadings and submissions of counsel, the petitioner's allegation of non-compliance with the Electoral Act 2022 and the regulations and guidelines for the conduct of elections 22 is anchored on the provisions of sections 47.2, 61.2 and 5, 64.4a and b, 64.5 and 73.2 of the Electoral Act, and paragraph 38.1 and 2, 48a, b, c, 55, Roman 5, 7 and 20, 51.2, 54.12 and 55.12 and 93 of the regulations and guidelines. I have carefully considered the submissions of the parties on this issue of non-compliance with the Provisional Electoral Act and the paragraphs of the regulations and guidelines for the conduct of the election 2022. The Independent National Electoral Commission, the first respondent herein, is established by Section 153, subsection 1F of the Constitution of the Federal Republic of Nigeria 1999, and part of its functions are stated on paragraph 15 in 18F, part 1 of the third schedule to the said Constitution, is to organize, undertake, and supervise elections, including election to the office of the President and Vice President, among other political officers listed. In a creation of the Constitution, INEC is empowered by Section 160, subsection 1 of the Constitution to make its own rules or otherwise regulate its own procedure, and in so doing, it shall not be under the control of the President. Indeed, by Section 158, subsection 1 of the Constitution, INEC shall not be subject to direction or control of any authority person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area councils of the Federal Capital Territory. Section 47, subsection 2 of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also, under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62 sub 1 of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with the election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64.4 states that the collation officer or returning officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that A, number of accredited voters stated on the collected results are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and B, the votes stated on the collected results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 60, subsection 4 of the Act. At this stage, it should be noted that Section 47, sub 2, referred to in Section 64.4a, relates to the procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 44b of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, Section 5 of Section 60 goes ahead to mandate the presiding officer to transfer the results, including total number of accredited voters and the results of the ballot in a manner prescribed by the Commission. The Act also provides in Section 64.5 that the collation officer or returning officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if a collected result at his or her lower level of collection is not correct. From the aforementioned sections, it is clear that while subsection 4 of Section 64 provides for what the collation or return officer will use to verify and collect the results, subsection 5 also provides for what the collation or return officer will use to collect the results. Subsection 6 of the same section provides for what the collation or return officer will use to determine the correctness of disputed result where there is a dispute. These are A, the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47, subsection 2 of the Act. And D, the votes and result of the election recorded and transmitted directly from each polling unit where the election is disputed and as prescribed under Section 64, sub 4 of the Act, which requires only the counting and announcement of results of the polling unit. A careful examination of the above sections, that opened by the petitioners, show that the Electoral Act had used the words deliver in Section 62, subsection 1, transfer in Section 60, subsection 5, and transmitted directly in Section 50, sub 2, 64, 4, 5, and 6 of the Electoral Act 2022, in stating how results of elections should be handled under those provisions. A look at the definitions of those words in the Black's Law Dictionary 6th edition shows that the word transfer is defined at page 1497 as to convey or remove from one place, person, etc. to another, or to pass or hand over from one to another, or to specifically to change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary to mean to send or transfer from one person or place to another, or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly, interchangeably, to describe how the results of the election shall be moved from one stage to another until the results are finally collected and declared. In all these, the Electoral Act 2022 has not specifically provided that the result of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, subsection 1 of the 1991 Constitution, and Section 148 of the Electoral Act 2022 that the first respondent does annex herein made the regulations and guidelines for the conduct of elections 2022, as well as annex manual for election officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal voter accreditation system, BVAS, as the technological device for the purpose of accreditation and verification of voters in the 2023 general elections. The petitioners have also hinged their allegation of non-compliance 7, 55.7 and 93 regulations and guidelines. Paragraph 38 of the regulation provides as follows. Extensive, get a copy of the guidelines, you will see here we have to produce it in this judgment. From the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 62, subsection 1, for the delivery by the presiding officer of the result along with other election materials under security and accompanied by candidates or their polling agents where available, such a person as may be prescribed by the first respondent. The first respondent has, by paragraph 38 of the regulations and guidelines quoted above, introduce electronic transmission to a collation system, in addition to the physical transfer of the election results to the registration area of ward collation officer. As stated earlier, the technological device as prescribed by ANIC in the conduct of the 2022 election is the bimodal voter accreditation system, BVAS. The function of the BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or her fingerprints or face facial recognition, thus accrediting the voter to vote at the election and storing the data and number of such accredited voters. By paragraph 38, 2 and 3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the ANIC results viewing portal, IREF, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area from ward collation officer. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit results and upload same to the IREF, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the result of the polling unit direct to collation system. It should be noted that the ANIC results viewing portal, IREF, is not a collation system. The Supreme Court in Oyetola and ANIC 2023, ANIC 23 LPELR, has explained the difference between the collation system and the IREF. In that case, IGIM JSC held as follows: court. As their names depict, the collation system and the ANIC result viewing portal are part of the collation process, the election process, and play particular roles in that process. The collation system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides a relevant collation officer the means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. The community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of elections 2022, and the ANIC Manual for Election Officials 2023 show that the Electoral Act provides in section 62, subsection 1, that after recording and announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines, as well as the ANIC manual, also state that hard copies of election results shall be used for the collation, and it is only where no such hard copies of the election results exist that electronically transmitted results or results from the IREF will be used to collect results. The petitioners who contend that ANIC was mandatorily required to electronically transmit the election results to the collation system have called PW2 as an expert witness who stated that he is a software engineer. He stated that he was aware that ANIC was mandated to electronically transmit or transfer the results from the polling unit direct to the collation system as prescribed by ANIC. He stated that the IREF portal is part of the technological architecture developed or deployed by ANIC for the storage, management, display, and uploading of polling unit results to be accessed by the public. However, under cross-examination, he admitted that he was not familiar with the operations and application of the BVAS machine, and that his investigations and findings were on the ANIC IREF portal. He also agreed that it was only ANIC that could prescribe the method of transmission of election results. PW4 was also called as an expert witness by the petitioners, even though he stated that part of his brief by Labour Party was to determine ANIC compliance with the Electoral Act 2022 and the ANIC regulations and guidelines for conduct of the elections 2022. He prevaricated under cross-examination by the first respondent when he first stated that ANIC and IREF portal is an electronic collation system, but later recanted and said the IRF portal is not capable of collating and or tabulating the results of an election. The witness also stated under cross-examination by the second and third respondents that it is the image of Form EC8A that will be transmitted to IRF, while the hard copy of the Form EC8A will be taken to the Ward Collation Center. As for PW7, also called as expert witness by the petitioners, her evidence was basically in respect of the health status of Amazon Web Service, which hosted the ANIC IRF portal. The testimony of PW8, the cyber security expert, also called by the petitioners, also related to the ANIC IRF portal. On the part of the first respondent, RW1, Dr. Lawrence Bayode, the Deputy Director in the ICT Department of the first respondent, has testified that contrary to the assertion of the petitioners in paragraph 37 of the petition, there was no collation system of the first respondent to which polling unit results were mandatorily required to be electronically transmitted or transferred directly by the presiding officer. He stated that the prescribed mode of collation was manual collation of the various forms EC8As, EC8Bs, EC8Cs, EC8Ds, and EC8Es for the presidential election. He explained that the Beavers machine was designed to upload accreditation data at the end of the accreditation process and scan and transmit the results of the polling unit results through the e-transmission system to the IRF portal. Even as this witness was cross-examined by the petitioner's counsel, he was not cross-examined on his evidence that ANIC has not established any collation system to which results will be electronically transmitted from the polling units. Thus, his testimony on that fact remained unchallenged and uncontroverted. It is settled law that the court has a duty to act on unchallenged and uncontroverted evidence. The Bromwen Energy Trading Company Limited, OAN Overseas Agency, Ogunyade versus Oshunke, and others. In addition, RW2, called by the second and third respondents, had testified that the first respondent, through its chairman, made clarifications on 23rd of February 2023 that raw figures of election results will not be transmitted electronically by the first respondent, as such transmission was susceptible to hacking. He identified exhibits R24 and RA24 and RA25 as documents he referred to in his statement. These are the certified true copies of pages 28 and 27 of Tribunal newspapers of 23rd February 2023, wherein the chairman made the said clarification. As indicated in our ruling on objections to documents, the petitioners did not object to the contents of exhibits RA24 and RA25, but only stated that they were objecting to the heading, but not the contents. We overruled that objection in our ruling because the reason advanced by the petitioners' counsel did not amount to a proper objection to those documents. Also noteworthy that the petitioners never cross-examined RW2 on his oral evidence and the said exhibits in support of his oral evidence. In exhibit RA24, the ANIC chairman was reported to have stated that raw figures will not be transmitted because the law does not allow for electronic transmission of results and because it is susceptible to hacking. He stated that only scanned copies of polling unit results will be uploaded to the RF for public view. From the evidence led by the parties on this issue, it is clear that apart from testifying that the first respondent failed to transmit scanned copies of polling unit results to the ANIC RF portal, none of the witnesses called by the petitioners had given evidence of the existence of any collation system to which the results shall be electronically transmitted by the presiding officers of the first respondent. Contrary to the contention of the petitioners that under the regulations it will not be possible to collect the presidential election results without verifying them with the electronically transmitted results, paragraph 92 of the same regulations categorically provides that at every level of collation where the ANIC copy of collected results from the immediate lower level of collation exists, it shall be adopted for collation. In addition, paragraph 48C of the regulations provides that if no result has been directly transmitted electronically for a polling polling unit or any level of collection, the provision of Clause 93 of this regulation shall apply. The said Clause 93 of the regulations, which I had earlier quoted, provides that where the annual hard copy of collected results from the immediately lower level of collection does not exist, the collection officer shall use electronically transmitted results or results from the IRF portal to continue collection. And where none of this exists, the collection officer shall ask for the duplicate copies issued by the Commission to the Nigerian police or to the agents of political parties in that order. The foregoing provisions of the Electoral Act and the earning regulations clearly show that it is not correct, as contended by the petitioners, that results of the election cannot be validly collected without the electronically transmitted results. Indeed, the regulations primarily provide for manual transmission or transfer and collection of results. There is nothing in the Electoral Act or the earning regulations and guidelines to show that an electronic collection system was prescribed by the Commission to which results will be electronically transmitted. Thus, the petitioners were unable to establish their assertion that the first respondent is mandatorily required to electronically transmit the polling unit results to a collation system. The first respondent, on the other hand, has adduced unchallenged evidence that apart from the IRF portal, no collation system was established by the first respondent to which results of the presidential election must be electronically transmitted for collation. It is therefore my finding that both the Electoral Act and the regulations and guidelines provide for manual collation of election results, and the electronic transmission to a collation system apparently introduced by the first respondent in the regulations and guidelines are not mandatory as contended by the petitioners herein. Also, my finding, based on the evidence adduced, that the only collation system put in place by the first respondent in the conduct of the presidential election is comprised of the fiscal collection centers in the registration areas or ward collection centers, local government area collection centers, state collection centers, and the national collection centers elaborately stated in paragraphs 47, 50, 53, 54, and 55 of the regulations and guidelines for the conduct of elections 2022. With regard to the petitioner's contention that the first respondent deliberately failed to upload the presidential election results to the INEC result viewing portal, RF real time, the petitioners averred in paragraphs 53, 97, and 98 the petition that the petitioner also 53. The petitioner also contend that in manifest violation of the first respondent regulations and the Electoral Act 2022, the results of the presidential election held in the polling units were not fully uploaded on the RF as at the time of the purported declaration of second respondent as the winner of the presidential election, which gave room for manipulation of the said results by officials of the respondent. 97. The first respondent, via a written communication, sought to excuse the manifest non-compliance with the requirements of the Electoral Act 22 and the regulations by claiming that there were glitches in the electoral system which prevented it, that first respondent, from uploading the results of the presidential election from the polling units to the RF portal on the day of the election. The said written communication is hereby pleaded. 98. The petitioner shall contend that the alleged glitches in the electronic system installed and managed by the first respondent were a ploy invented by the first respondent to credit unlawful votes to the second respondent and thereby wipe out a clear advantage which inured to the petitioners following the lawful exercise of voting rights by the electorate. In response to the above allegation, the first respondent adverted in paragraphs 59, 55, 7, 8, 9, and 10 of their reply to the petition. I will reproduce them here. In paragraph 37 of their reply to the respondent's reply, the petitioners have again denied that there was any technical glitch and maintained their assertion that the failure to upload the results on the IRF was a ploy by the first respondent to manipulate the results. They stated that they will rely on the server logs and server contents of the IRF hosted on the AWS cloud platform to show that the results of the election were uploaded on the IRF portal, but the first respondent attempted to delete or remove the uploaded results. It is true that a petitioner who alleges non-compliance with the Electoral Act has the legal burden to establish that non-compliance and show how the non-compliance substantially affected the result of the election. Ladoja and Ajimwabi, Shinkafi and Yari, in proof of their assertion, the petitioners subpoenaed PW7 and PW8 as expert witnesses, but the respondents challenged their competence to testify because their witness statements on oath were not front-loaded along with the petition, as mandatorily required by paragraph 4.5 of the first schedule to the Electoral Act. In my ruling at the earlier part of this judgment, I had upheld the respondents' objection and struck out the evidence which include their witness statements on oath and the documents and or reports tendered through them. These are exhibits PCJ-A to F, PCJ-4, 6 reports of AWS health dashboard status and certificate of compliance tendered through PW7, and exhibit PCK-1, metadata admitted through PW8. However, notwithstanding that position, I shall proceed to consider the evidence of PW7 and PW8 and the other witnesses called by the petitioners. PW7 claimed to be a cloud engineer or architect, an employee of Amazon Web Services. She stated that she is not only a member of the Labour Party, the petitioner is share in, but she contested election as a candidate for member House of Representatives for Ogoja, Yala, Federal Constituency of Cross River State. She stated that for an IT application, the SDLC includes requirement gathering, analysis, and design. Collation centers and design, yes. The development from implementation, testing the code, staging the software and development and deployment. She stated that she was aware that at the process of testing and staging of software code and problems or challenges, any problems or challenges with the software will usually show and or be flagged. He stated that each function is supposed to be tested and any issues flagged ought to be remedied before deploying the software. He stated that if a software from application has any glitch, such a glitch will pop up. That is flagged at the testing stage. He stated that from her preliminary review of the public viewing facing the RF website, she is aware that the polling unit results images are stored in Amazon S3 and AWS storage service. She stated that as an employee of AWS, the AWS has a service level agreement, SLA, with its customers, which is accessible to the public on docs.aws.amazon.com, and that by the SLA for S3 service, it is designed to provide 99.999% durability and 99.99% availability of objects stored over a year. He said this is accessible to the public on http://docs.aws.amazon.com, Amazon S3 latest user guide data durability.html. He stated that the AWS cloud servers are hosted in 33 regions. The health status of AWS cloud service for all regions for the past 12 months from date is accessible to the public on http://health.aws.amazon.com from health/status. It stated that the health status of each service in each region on February 25, 2023 indicated that there were no glitches on any of the AWS cloud servers. It stated that from the post-event summary is by AWS, the last time a significant outage occurred on the AWS cloud servers was on December 10, 2021, which was an internal connectivity issue that affected EC2, API, and Container API, among other services access issues affecting only one region. He said this is available to the public. AWS 7 stated that she was aware that a glitch in the software means a malfunctioning, as a result of which the application is not able to perform properly, and that fixing a glitch in a software application by the creation of patches refers to a series of changes made into the system by writing small code, which is imputed into the software to change its current state and thereby function properly. On cross-examination by the first respondent, PW7 admitted that she missed production maintenance, which is an important element of software development life cycle. He denied that glitches occur at post-production maintenance stage and stated that it appears at the testing stage. He stated that she was aware of personal health dashboard, but stated that the first respondent's personal health dashboard is not before the court. He admitted that the AWS adopts a shared responsibility model in which AWS plays its part while the customer plays its own part when it comes to security. He admitted that the report that only shows the health status of all AWS services in all regions in terms of the infrastructure and not security. He admitted that in order to know what happened on applications deployed on AWS infrastructure by a customer, it is not necessary to get a technical report. PW7 also stated that she is familiar with AWS CloudTrail, and there is a CloudTrail for every AWS account, API action made on that account. She admitted that she did not produce the CloudTrail for any deployed application before the court. He denied that the CloudTrail is the best account of what transpired on any deployed application, but did not state the best way to know what transpired. In MTN Mono PSG, he admitted that she was a candidate for the Labour Party at the last election. He also admitted that the subpoena under which she came to court was served on her personally and not on Amazon Web Services. Also on cross-examination by the second and third respondents, PW7 admitted that Exhibit PCJ2, which she presented as her employment verification letter, was not signed by anyone, but insisted that there is the name of Employment Resource Center written on it. She also admitted that she had been attending the court and watching the proceedings before the day of her testimony. She admitted that the report she presented before the court is public information posted by Amazon and that it is available and accessible to the public. She, however, insisted that the report is hers because she was the one who downloaded it, brought them to the court. PW7 also admitted under cross-examination that she won primary election for her constituency under Labour Party, the second petitioner, and that she even filed an action against INEC because she was not placed on the final list of candidates published by INEC. She admitted that her complaint was because she tried several times to upload her information on INEC's site, but all her efforts failed because of network failure. She admitted that network failure can happen to either end of an application, even as she disagreed that there was a glitch on INEC's site. She admitted that in her affidavit. She stated that INEC's site crashed. PW7 also stated that she was aware that EWS experienced outage of several hours on Tuesday, 28 February 2017, and that as at 2021, AWS also was reported to have suffered more than 27 outages. He also admitted that what was sent to RF was the image of the Form EC8A. On cross-examination by the fourth respondent, PW7 stated that she did not know about password protocols and cannot speak about password protocol to modify the applications of INEC. She admitted that the open cross-access information she downloaded in her report cannot be amended by her. In fact, she admitted that she was not representing Amazon Web Services in this case. However, insisted that she is an expert. She stated that she was aware of glitch which affected Japan brokers in September 2021, but stated that the last one she was aware of was in December 2021. As to whether glitches can happen again, she stated that anything is possible. In his evidence, PW1, Dr. Chibike Ugoike, another expert witness called by the petitioners, stated that he is a cybersecurity and risk advisory consultant and that he was approached by the Labour Party to provide expert evidence in this petition. He said he had read the Electoral Act 2022 and the INEC regulations and guidelines for the conduct of elections 22 and the INEC manual for election officials 2023, with particular attention to the relevant provisions dealing with uploading and transmission of election results from the polling units using the beavers to IRF portal. He stated that he has also read the petition as well as the reply to the petition filed by the first respondent. He stated that from his reading of those documents and processes, when a software application undergoes the required minimum testing for deployment, any functionality error or bug will be flagged. He stated that the purpose of testing is to remedy or resolve such errors before the application is deployed for production. On cross-examination by the first respondent, PW8 stated that he was approached on 10th March 2023 and he finished his work sometime in May 2023. He said that he did his preliminary report on 17th and 18th March. On 17th and 18th March 2023 and concluded the final report at the end of May 2023. PW8 stated in paragraph 14 of his adopted written witness statement that he read the petition and the first respondent replied to the petition in doing his work, stated that he could not recall whether he read the petition. But when his attention was drawn to paragraph 14 of his statement, he agreed that he had read those pleadings. He admitted that it is not impossible for errors to occur after deployment of technology or application. When referred to paragraphs 22 and 23 of his statement, he stated that he referred to the metadata on the IRF in 3 polling units. He established that it is possible to show metadata. He stated that there were errors in those polling units and he did not have to examine the physical copies of the forms EC8A of those polling units. He stated that from the tabulation of the metadata, he could not tell that whether the results stated in those polling units were collected. He stated that all the work he did was on his computer. He confirmed that the AWS security model is a shared responsibility model between AWS and the client. He stated that he was aware of the CloudTrail and confirmed that the CloudTrail will explain the availability of the application of INEC on the AWS infrastructure. PW8, who insisted that there was an electronic collation system, only pointed to an upload at the last paragraph of Exhibit PCK2 and stated that it means an electron. Instead, that the information he provided are decrypted and readable. He admitted that he supplied some links in some paragraphs of his report that stated he did not expect the court to go and browse, access, and download the information contained from those links. When cross-examined by the first respondent, PW admitted that he downloaded the 12 polling unit results he attached to his report from the IREF, and he did not interact with the presiding officers of those polling units and did not see the hard copies of those results. He could not also tell whether those results have been collated. Starting with the evidence of PW7, there's evidence that she is a person who has an interest to serve in this petition, being a member of the second petitioner, under whose platform she contested election for House of Representatives. Her interest in this petition is further underscored by her admission that she has been attending court and watching the proceedings prior to making her statement on oath and testifying as a witness. Her testimony, therefore, was essentially a demonstration of her support and loyalty to the second petitioner. Her claim to being an employee of Amazon Web Services is also suspect, as she produced no credible evidence to that effect. Exhibit PCJ2, which is the paper she presented as evidence of her employment by AWS, is obviously a worthless paper. It has no author, although she insisted that the author is Employee Resource Center. The paper was also not signed. Her evidence adds no value to the petitioner case because she stated that her evidence relates to the health status of AWS in terms of infrastructure and not in terms of security. She had admitted that the expert report in Exhibit PCJ 3A to F, which she brought to court, are actually documents publicly available on Amazon website, which she downloaded, and her only claim to its ownership is that she was the one who downloaded it and brought it to court. She even admitted that she could not add or subtract anything from the reports. Those reports are obviously not her own. She also admitted that the health status of the first responder's application posted on the AWS is not before the court. Her conclusion on the totality of value of this witness is that it is devoid of any probative value. As for PW8, he has demonstrated that he worked to an answer. Not only did he admit that he read the petition and reply of the first respondent in the course of his commission work, he also stated that he read the Electoral Act and annual regulations and manual for election officials. On the authority of Ladoja and Ajimobi, the evidence of this witness is also not of any probative value. Apart from the above, the other witnesses or petitioners, especially PW4, PW9, 10, 12, and 13, all stated that they voted and everything went well in their respective polling units. In particular, PW4, PW10, and 13 all stated that their polling unit results were taken to collation centers. Therefore, even the evidence of the petitioner witnesses showed that the polling unit results were physically taken to the registration areas for work collation centers. The petitioners have led no evidence to establish the existence of any collation center to which the potential election results were to be electronically transmitted for collation. On the part of the first respondent, RW1 testified that the failure to upload some of the results of the presidential election to the IRF portal real time on 25th February 2023 was due to a technical glitch experienced on their e-transmission system. RW1, through whom the first respondent tendered exhibits RA6 and RA7, stated that at the end of the polls, in some polling units, on 26 February 2023, it was observed that the first respondent It was observed that first respondent, that polling unit results being uploaded to the Annex e-transmit system by the presiding officers were pushed to the Senate and House of Representatives modules on the IREF, but the results of the presidential election were not being pushed to the presidential model on the IREF. That based on threat levels and reports by security agencies that the first responder servers may be subjected to attacks on election day, the first responder first course of action was to investigate whether the servers were being attacked. The preliminary investigation showed that there was no attack. But the issue was a HTTP 500 error from which the application, within the application, which are mostly errors due to problems of configuration, permissions, or failure to create application resources correctly. That a thorough investigation revealed that the transmission was unable to map the uploaded results of the presidential election to any specific state, and that the presidential folder structure, which was meant to organize the uploaded result sheets in order of election, state, local government, area, ward, polling unit, was causing the application to crash and return as server error whenever it tried to create the folder structure for the presidential election. RW1 explained that creating a folder structure to organize the uploaded results in the hierarchy of election, state, local government, ward, and polling unit was a new feature introduced as an improvement in the transmission system, and that the old system randomly saved uploaded results by timestamps, making it difficult to upload results sheets by election or by state. He stated that the deficiency was observed after the Ocean State governorship election in 2022. RW1 stated that during the election of 25 February 2023, the application was able to query and detect the base states for the senatorial districts and federal constituencies based on the mapping of all central districts and federal constituencies to their respective states. And that this mapping still exists in the database. And the upload was successful because it was able to identify the state and build the folder hierarchy for the results organization. But for the presidential election, the application crashed because the presidential election does not belong to any state on the first respondents database, and any attempt by the application to build a folder structure to organize the election results failed with a HTTP error response. RW1 stated that since these were live servers that were being used for the election, extra care was taken not to cause a complete outage, and four application patches or updates were created and deployed immediately with the aim of fixing the HTTP error. He stated that the first presidential election results was successfully uploaded at 8:55 p.m. on the 25th February 2023. He further stated that to confirm that the glitch actually happened, as well as the time that all patches to fix the error were created and deployed, can be viewed on AWS Cloud Trail and AWS functionality that allows enabling operational and risk auditing. He added that all actions taken to fix the error are recorded as events in the Cloud Trail logs. He stated that the technological glitch experienced on the e-transmission system was not deployed to manipulate the election. Transmission system, the first respondent, when shown a report produced on subpoena, he identified same as a report on vulnerability assessment and penetration testing data dated 22nd February 2023, but stated that it was not the report of testing carried out on the e-transmission system, 4th February 2023. The petitioners then tendered the report of vulnerability assessment and penetration testing through its witness, which was admitted as X1. From the evidence adduced on this point, it is clear that the petitioners are unable to substantiate their contention, the burden of proof of which was on them by virtue of Section 131, subsection 1 of the Evidence Act 2011. They have failed to establish that the first respondent had deliberately failed to upload the results of the presidential election to the RF in order to manipulate the results in favor of the second respondent. The first respondent, on the other hand, has offered credible evidence in the form of Exhibits RA6 and RA7 to show that its e-transmission application posted on the Amazon Web Services, which is supposed to upload the results of the presidential election to the RF, has suffered a glitch on the election day on 25th February 2023. On the preponderance of evidence, I am convinced that the petitioners have failed to establish their assertion that the first respondent had deliberately failed to upload the results of the presidential election to the RF in order to manipulate the results in favor of the second respondent. As I stated earlier, the electronic transmission system of electronic transmission of results of an election is not expressly stated anywhere in the Electoral Act, but was only introduced by the first respondent, that is ANIC, in its regulations and guidelines 2022, and in the ANIC Manual for Election Officials 2023. By Section 134, subsection 2 of the Electoral Act 2022, only an act or omission which is contrary to the Electoral Act 2022, can be a ground for questioning an election. Thus, complaints relating to non-compliance with provisions of the regulations and guidelines or the manual of election officials are not legally cognizable complaints for questioning an election. In interpreting Section 138, subsection 2 of the Electoral Act 2010, which is similar to Section 134.2 of the Electoral Act 2022, the Supreme Court held in Nyesom and Peterside as follows. Quote, the above provisions appear to be quite clear and unambiguous. While the Electoral Commission is duly conferred with powers to issue regulations, guidelines, or manuals for the smooth conduct of elections by Section 138.2 of the Act, so long as an act or omission regarding such regulation or guideline is not contrary to the provisions of the Act itself, it will not of itself be a ground for questioning the election. See also Jegede and INEC. Admission of election results is not specifically provided for in the Electoral Act 2022, but was only provided for in the regulations and guidelines for conduct of elections 2022 and INEC Manual for Election Officials 2023. The failure to electronically transmit election results cannot be made a ground for challenging an election under Section 134, subsection 1B of the Electoral Act 2022. The petitioners also allege in paragraph 59 of the petition that the first respondent failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials on the prescribed forms EC 25A, EC 25A1, EC 8B, and EC 8B1. That is to say, electoral materials received for local government areas, electoral materials distribution for registration areas, electoral materials received for local government areas, electoral material distribution for RAs, electoral materials received, reverse logistics, and polling unit materials in respect of states where the respondent is purported, where the second respondent purportedly won. The petitioners further allege that following the order of court for inspection, they applied through their campaign organization and lawyers for the forms, but the first respondent refused to give or issue those forms and refused to allow the inspection of the forms despite the order. In response to the petitioner's allegation, the first respondent countered that its officials duly recorded in the prescribed forms the quantity, serial numbers, and other forms, other particulars of the result sheets, ballot papers, and other sensitive electoral materials in the prescribed forms EC 25A, EC 25A1, EC 8B, EC 8B1, in respect of the states where the second respondent duly won the election, as shown in the states where the petitioner won the election, as the procedure adopted in the election across all the states of the Federation are uniform and the same. The first respondent further stated that it duly complied with the order of inspection granted by the Honorable Court, and the petitioners were not denied access to the EC forms EC 25A, EC 25A1, EC 8B, EC 8B1, as alleged by the petitioners. It was the subordinate senior counsel with regard to the state of the pleadings and the issues of fact in contention. The onus is on the first respondent to prove that there was indeed due compliance with the provisions of Section 73, subsection 2 of the Electoral Act, since petitioners are asserting the negative, while the respondents are asserting the positive. They relied on the decision of this court in First Bank Nigeria PLC, Admissibility Business Investments, and Royal United Nigeria Sterling Bank PLC, admitted that the first respondent did not leave any evidence in proof of their positive assertion there was compliance with the state provision of Section 73, subsection 2 of the Electoral Act. Learned Counsel submitted that on the part of the petitioners, they have led evidence through PW 12 that the petitioners obtained order of this court for inspection of documents, but the first respondent had refused to produce the forms, despite several letters demanding the forms from the petitioners, which were tendered as exhibits PCQ1 to PCQ6. He added that the petitioners have also served subpoena duties take home on the first respondent to produce the said forms is the forms, but the officer of the first respondent, the deputy director, certification, complaints, and legal drafting, who came to court in answer of the subpoena on 20th June 2023, failed to bring the form. Counsel asked the court to invoke the provision section 167D of the Evidence Act against the first respondent and hold that the forms, if produced, would have been unfavorable to the first respondent. He further submitted that the non-compliance with section 73(2) of the Electoral Act has been established, which has invalidated the election in those states which the second respondent was declared to have won, namely Benue, Borno. Respondent referred the court to section 135(1) of the Electoral Act 2022 and submitted that the petitioner complaint of non-utilization of prescribed forms, even though not proved, cannot without showing the effect on the election be a basis to avoid an election. He submitted that the attempt by the petitioners to exclude section 73, subsection 2 of the Act from the ambit of section 135, section 1 is a non-starter because the non-compliance referred to in section 135(1) is for the provisions of the Act, and no part of the Act was excluded by the section. He posited that for non-compliance with section 73 of the Act to avoid an election, it must have substantial effect on the election, and the petitioners have neither proved such non-compliance nor shown that it has substantially affected the result of the potential presidential election. I urge the court to so hold. Petitioners have contended that since they are alleging that the first respondent failed to record in the prescribed form the quantity and particulars of the materials used in the election, they are alleging a negative, and as such, the burden is on the first respondent to establish that they have duly complied with the provisions of section 73 sub 2 of the Electoral Act. They have relied on the decision of First Bank of Nigeria versus Admissibility Business Investment Limited, Royal United Nigeria versus Sterling Bank. While it is true that the burden of proof is generally on the party that asserts the affirmative for an issue and not on the party who asserts the negative, there is an exception to that general principle. Where a negative assertion forms an essential part of the party's case, the burden is on him to establish that fact. This position was clearly stated by the Supreme Court in the case of Buhari and Anik, where Toby JSC stated held thus, quote, a negative allegation must not be confounded with the mere traverse of an affirmative one. The true meaning of the rule is that where a given allegation, whether affirmative or negative, forms an essential part of a party's case, the proof of such allegation rests on him, close of court. Again, this court in Dashe and others versus Druven and others espoused this legal position when Hugo JCA held as follows. Quote, I am in no doubt that this argument of appellants about negative and positive assertion is misconceived. For while it is true that the burden of proof is generally on the person who substantially affirms the positive of an issue and not on the person who makes a negative assertion, there is a caveat to that principle to the effect that where a negative assertion forms an essential part of a plaintiff's case, as it evidently is the case of the appellant, the burden of proof of such allegation rests on him. The law on this point was lucidly stated by Bowen LJ and Abra was a Northeast Railway Company, 11 Queens Bend Division 440 at 457, when he said that, quote, in an action for malicious prosecution, a plaintiff has the burden throughout of establishing that the circumstances of the prosecution were such that the judge can see no reasonable and probable cause for instituting it. In one sense, that it is the assertion of a negative, and we have been praised with the proposition that when a negative is made out, the onus of proof shifts. That is not so. If the assertion of a negative is an essential part of a plaintiff's case, the proof of the assertion still rests on the plaintiff. The terms negative and affirmative are, after all, relative and not absolute. Close of court. In the instant case, the petitioners have made their allegation of non-compliance with section 73(2) of the Electoral Act 2022 by the first respondent as an essential part of their case in challenging the results of the election declared by the first respondent. Not only are the petitioners statutorily required by Section 135, subsection 1 of the Electoral Act to establish substantial non-compliance with the provisions of the Act, they are required to show how such non-compliance has substantially affected the result of the election. As rightly observed by the learned senior counsel for the first respondent, the non-compliance that will not invalidate an election under Section 135(1) unless it is shown to be substantial and to have substantially affected the result of the election. It encompasses non-compliance with all provisions of the Electoral Act, including Section 73, subsection 2 thereof. In other words, Section 73, sub 2 is not derogated from the ambit of Section 135, section 1 of the Act. Indeed, in Buhari and Anik, Toby Joy is while considering considering Section 145(1) of the old Electoral Act, similar to Section 135(1) of the Eastern Electoral Act 2022, had held at page 48, paragraphs B to D that, quote, a petitioner who files a petition under Section 145(1) of the Electoral Act has the burden to prove the ground or grounds. This is because he is the party alleging the grounds and he has a duty to prove the affirmative. He is the party who will lose if no evidence is given on the grounds. If the party does not prove his case under Section 145(1) of the Act, the action fails. Therefore, the petitioners who have alleged non-compliance with the Section 73, subsection 1, as part of their course of action, have the burden to establish that non-compliance in accordance with the requirements of Section 135(1) of the Act. The petitioners have also relied on the evidence of PW12 and on exhibits PCQ1 to PCQ6, also tendered through PW12. The exhibits are acknowledged copies of letters dated 6 March 2023, 14 March 2023, 16 March 2023, and 20th March 2023, all written by the petitioners or their solicitors to the chairman or the first respondent, demanding for inspection of documents and for certified true copies of the electoral forms. The petitioner also relied on subpoena duces tecum served on the first respondent to produce the said form. In his testimony at paragraphs 58 to 60 of his adopted written statement on oath, PW12 merely stated that the petitioners made several applications through his campaign organization and solicitors for certified copies of election documents and data relating to the presidential election, but they were denied by the first respondent, and that the first respondent had failed to record in the prescribed forms the quantity, serial numbers, and other particulars of result sheets, ballot papers, and other sensitive electoral materials. The record of proceedings of this court also shows that at the instant of the petitioners, subpoenas dated 30th May 2023 and 13th June 2023 were issued on the chairman of the first respondent to produce some documents. The record also shows that on the 20th June 2023, one Olu Finmilayo Taiwo, the Deputy Director of Certification on Complaints and Legal Drafting with ANIC, appeared on behalf of the first respondent in answer to the subpoena duces tecum. While she produced some of the documents required of the first respondent in the subpoenas, she informed the court that the documents listed in the subpoenas as listed E, C, D, and E are in the states, and since the subpoena was served on them just before the previous day, it will take some time for the first respondent to get them. An examination of exhibits PCQ to PCQ6, which were tendered by the petitioners through PW12, showed that all except exhibit PCQ are letters addressed to the chairman or the first respondent by the petitioners and their solicitors requesting for inspection of documents and for certified copies of those documents. Exhibit PCQ4 is a covering letter addressed to the resident electoral commissioner, Benue State, from the law firm of Dr. Paniechi Piazzo, SAN and Co., notifying the respondent of the resident electoral commissioner of subsequent action on the solicited letter by the National Chairman, ANIC Headquarters, Abuja, dated 6 March 2023. It is instructive to observe that Section 74(1) of the Electoral Act 2022 23 mandates the resident electoral commissioner in a state where an election is conducted within 14 days after an application is made to him by any of the parties to an election petition, cause a certified true copy of such document to be issued to the said party. Subsection 2 of that section even provides that any resident electoral commissioner who fails to comply with subsection 1 commits an offense and is liable on conviction to a maximum of 2 million naira or imprisonment for a term of 12 months or both. A look at the letters exhibits PCQ1 to PCQ6 showed that they were all addressed to the chairman of ANEC instead of the resident electoral commissioners in the states as required by the petitioners by section 74 subsection 1 of the Electoral Act 2023. It is therefore clear that the petitioners have failed to follow the clear legal procedures of requesting for those documents. More so, when the record shows that the subpoenas which they claim to have served upon the first respondent were also served on the chairman of the first respondent, and as stated by the officer who answered the subpoena, same was served only the previous day for her appearance in court. From his evidence, PW12 had stated that apart from voting at his polling unit 04 at Dawaki, Abuja, the only role he played in the 25th February 2023 general election, presidential election, was that he was a member of the second petitioner's special room. And on cross-examination by the respondent, he stated that he was neither a polling agent nor a collation agent. His evidence that the first respondent had failed to record in prescribed forms the quantity, serial numbers, and other details of the electoral materials can only be hearsay evidence, which has no probative value. Also, the mere production of exhibits PCQ1 to PCQ6 cannot establish an allegation of non-compliance with section 73(2) of the Electoral Act. The Electoral Act 2022. Apart from the evidence of PW12 and exhibits PCQ1 to PCQ6 tendered through him, the petitioners have produced no other evidence to substantiate their allegation that the first respondent failed to